Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Alrighty, took a little bit there to get set up. I realized I had turned the subwoofer off. You guys hear that? When I guess this morning and this afternoon when I started the stream, the bass wasn't turned on for my music, so it sounded very thin. But I turned it on about halfway through. Hopefully, it didn't scare you to death. Let's see. We're getting ready. Sorry, I'm a little bit discombobulated. I'm discombobulated right now. It's the word of the day. ASMR moment coming soon. I'll get this. I'm using switch to the pink mug during lunch. So let's see here. We have a trial, and it's funny. Normally, I'm waiting for the judge, and so I'm like watching things. But I can control when the judge starts on this one, so it's weird. So welcome back from lunch. Hope you had a fabulous one. Good to have you back here. Let's see. I do want to get that fixed. I think that's good. This is good. Let's see who all is here. We have well, most importantly, if I can hit the right button. All rise. Adam Nuski, congratulations on winning the internet yet once again. First in chat wins the internet with each time we live stream. And Adam, that is you today.
It's not relevant.
It's not relevant to the court case, but it's important to Adam because he has a serious job ahead of him, keeping track of everything IP related and keeping everything functioning too, connected, communicating, high speed. And I think, Adam, we're going to add to your duties today. All customer service calls related to the internet are also going to be directed to your cell phone. So hopefully that won't be a problem for you. It shouldn't be, much to handle. I'm not here, just gifted one recovery addict membership. Thank you so much. I'm not here. Clearly you are. And it looks like Double Agent 205 was gifted that membership by someone who's not here. So thank you very much. Appreciate that. Welcome. We're starting with, we're not starting with, we're finishing with day 3 of this trial. So there are 2 days ahead of us. We are going to be catching up as we watch a little bit higher speed, 1.25 speed, as well as cutting out all the breaks. We're going to get up to speed because this case is interesting. Things are happening even today. Things are happening that are exciting that might become an issue as this case develops. We're going to have a lot of time to catch up. We'll be caught up before midweek, I think, for sure. But let's go ahead and start this.
Several things that before the first witness is called that the parties would like to address with the court pertaining to stipulations and things of that nature. So I believe that would be more appropriately done now before the first witness is called.
Okay, so that's legalese for scram.
So
now you
jury
can
gets
go,
kicked
and
out. While they're leaving,
try again to keep it at
look at that tie.
Couple of minutes. But you're welcome to go upstairs if you want, or otherwise you may remain down here in the library.
Apparently, the jury just have free roam of the courthouse.
This will take
when they're not here.
Under 10 minutes, maybe 5.
Okay, so while they leave, we're going to do a little ASMR
In the meantime,
moment.
What are we hoping?
If I can talk to someone from Court TV.
Adam. Adam Nuski, please come to the judge's chambers.
My computer cranked up this morning.
Adam Nuski, paging Adam Nuski.
Wondering if something got detached while you were up here. I'm not blaming you. I don't want to call IT unless I have to. It won't stay on. I mean, the light goes on, so there's power.
This is clearly a first for our internet winner to have to handle an issue with the judge's computer personally. So, Adam, if you could get that squared away as soon as possible to allow us to continue watching the trial, that would be great.
Are we going to address subject matter jurisdiction?
We probably should. The jury's leaving the room here. Adam's fixing up the computer. Give him just a second. Let's see, what time is it here? We're on 23:40. I just want to check. I'm not sure if they show us this part or not. Okay, we jumped ahead, saved a couple minutes there. We need 3150. And here we go. Okay, we're going to be coming back. It's fun to have this time machine.
Entitled Stipulated Facts Regarding Statements of Unavailable Witness, Lene Douglas. And would you like it read or just in the record? And I'll, at the appropriate time, it'll be given.
Yeah, I'd like us to be able to read it to the jury as part of the evidence. My proposal to the court is that at a time that I would have called Ms. Douglas, which will be this morning, which is why we bring it up now, that the court will allow us to read it. I will either read it in its entirety, or if defense counsel wishes to in some way read the first portion, the paragraph that is regarding Officer Paul Chase's report, I of course have no disagreement with that. And then I will read the second half to the jury, and then of course the court can have that stipulation in evidence. But we'll read it. I'll read it verbatim, or we will both read it verbatim. Ms. Douglas is having medical issues that both parties are aware of. That's why we've tried to reach this stipulation to prevent her from having to be present. She has no prior convictions, so in terms of any impeachment, we're also aware of that.
Red Pen, this prosecutor,
the stipulation?
all his ties, or both of them,
that is correct, Judge.
are
and
pre-knotted.
The defense would prefer that we read the portions as it relates to Officer Paul Chase's reports, and then the state will read the portion as it relates to the telephone call that was had with their victim witness coordinator, Heather Beasy. So that would, and we have no objection to it being read at the point where the state would have called Lene Douglas. We think that's appropriate because that will be around the time that other residents of Wood Creek apartment will be called. So it would only make sense to read that stipulation in then and there. I have given a copy of the stipulation to Mr. Anderson. He has read that and is, as far as I know, unless it's changed now, is in agreement with the stipulation.
All right. Do you fully understand what is contained in the stipulation? And any questions about it at all? By stipulating this, that means the witness will not testify, and instead the jury will be read this stipulation, and it's stipulated facts. That means that the jury will be instructed that those are proved facts in the case, and there'll be no testimony admitted either to reprove those facts or those assertions, and there'll be no testimony permitted to disprove it. Stipulation means it's agreed. Is that clear?
Yes.
Any question about this at all?
No.
Has anybody threatened you, pressured you, or forced you in any way?
No.
Has anybody promised you anything?
He almost went there. He's like, what? Right. No.
Anything else then before we start?
Just that the first witness the state intends to call, Detective Lauren Anschutz, has no prior convictions. And another witness that we would call, hopefully without needing an additional break, would be Marissa Swanigan. She's the individual who's here on the warrant. She also has no priors. And so I believe that in terms of these early witnesses that we would call before there would be any additional breaks, that I think we've met our obligation to let the court know about any prior convictions.
Okay.
And we are in agreement with that calculation to the witnesses that the state just mentioned, and as the state said, we'll work diligently in getting the other convictions for the other witnesses to present to the court at a later time.
So let it be written, so let it be done.
I believe we're ready then, Judge, at this point.
I've never heard a defendant speak so much in a trial ahead of their option to testify. Fun fact, the judge's yellow tie that he's wearing is made out of the material that the gentleman's suit was made out of. I think it's actually part of that gentleman's suit that was sitting behind Alex Murdaugh the other day. The banana suit, if you remember correctly. I think that's what he made it out of. This is not the same judge. This is a different judge. The judge that shocked the defendant was the judge in the Aaron Dean trial. He's the one that had a shock collar or something put on the guy and zapped him a couple times, or shock cuffs or shock ankles. Yeah, and he's still on the bench. That's an interesting story. We can get into that sometime. Let's see. We have. I am running a limiter, so for headphone users, it can get loud, but it shouldn't blow the top end off on the volume.
How did we do that time-wise? Pretty good. All right. Close. Okay.
State calls
all right,
Incredible
thank you.
Hulk.
Go ahead, Mr. Gravely.
Your Honor, the state calls Detective Lauren Anschutz to the stand.
Thanks to all those who subscribe to Ivan Victor's YouTube channel. Sounds like he picked up a couple dozen or so subscribers. If you like pets, if you like dogs, you're going to like Ivan's channel. Plus, if you like Ivan, I mean, I guess he's a key part of that channel as well. That's awesome. We'll have to post the link here again at the end of this one. Don't let me forget, Ivan. I can crank the power on the limiter a little more.
I do solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Detective Anschutz, can you state your first and last name and spell both your names for the record?
Lauren Anschutz, Loranschutz.
Detective, how are you employed?
City of Kenosha Police Department as a detective.
How long have you been a detective?
Approximately 7 years.
And how long have you been a police officer with the Kenosha Police Department?
Just under 20 years.
During that time period, have you had an opportunity to investigate scenes where blood was present?
Yes, several.
And
just a couple.
Do you have an estimate in your 20 years how many times you've come across a scene of that type and had to make some sort of decisions regarding either what to do next or what there was there?
It's several hundred.
In that capacity as being on duty as a detective, did you come on May 19th, 2020 at just after 11 a.m. To be at a particular location that you were asked to go to?
Yes, I was told to go to 3709 15th Street for a suspicious incident.
And when you got there, were you the first officer on the scene?
No, there was multiple officers, a sergeant, another detective, and yeah.
Would that be uncommon that other officers would get there before a detective for a call like this, or would that be standard that detectives would not be called in as the first officers to arrive?
Yeah, I've never been called first as a detective to respond to any scene. Typically, the officers will respond, make an assessment, talk to a supervisor, and then we will be notified to respond.
And when you arrived, I don't want to know all the details, but what were you in general appraised of? So what were you told in general was the situation when you arrived before you made observations for yourself?
I was told that apartment 1B had a substantial amount of blood inside. It appeared as though there was a major incident occurred in the apartment and nobody was located.
And was that information provided by law enforcement?
Yes.
Were you provided information that the person reporting this was still on scene?
Yes.
And did you have a chance to interact with that individual?
Yes, I spoke with her, Sadie Beecham.
Okay.
Sadie Beecham was on scene. She was sitting in her car at the time I spoke with her.
And did you come to believe that Ms. Beecham had not fully entered the threshold of the residence, had not walked through the residence before calling law enforcement?
Correct.
Okay. So based on that, would your role in this case be to specifically search for a body or somebody within that residence, or would that be the role of other people who were at the scene?
That would have been the role of the responding officers to preserve life, to make sure the scene is secure.
Okay. And back before you were a detective, were you in that role many, many times over your career?
10 years, yes.
Okay. And so in that earlier role than yours, would it have been a priority to search for a person and not worry about what the evidence was, or are you already an evidence preserver in that first role that you described?
I'm going to object as far as leading.
Well, it had an alternative, so the objection's overruled.
Go ahead.
Can you rephrase, or can you?
Sure.
Love the objections.
Sure. In that earlier role, is the priority to do the search as quickly as possible, or to meticulously try to preserve evidence, like not step in things, et cetera, et cetera?
In those situations, you're concerned about the safety of others. That's your main focus and priority at that moment, as well as scene security. We don't know if anybody's in there. So that's what you're vigilant of when you first enter, and then obviously after you can slow down and then focus more on the preserving.
For those that are keeping score,
so I want to turn your attention to the address one more
prosecution.
time. You said it was 3709 15th Street, apartment 1B. Do I have that correct?
Correct.
And do you know, is that a part of a complex, or is that an isolated single-family location?
So it's a larger multi-building apartment complex. I believe there's 3 or 4 different addresses per building. 3709 is a mid in the middle of one of the buildings with an entry door specifically to that address on both the west, or north and south entrances of the apartments. You can enter either side. Once entering, there's 4 apartments downstairs, 4 apartments upstairs.
This is the detective.
So this specific
police
building that you're
detective
speaking of so far has 8
right
apartments. Did I get that correct? 4 up and 4 down?
3709 15th does have 8 apartments, yes.
Okay. And you are focused, of course, on one apartment of those 8. Is that true?
Number 1B.
Okay. Is that location, is that overall complex, does that have a name here in Kenosha?
Yes, it's called Wood Creek Apartments.
Okay. And is that address specifically in Wood Creek Apartments, that 3709 15th Street, is that in the city and county of Kenosha?
Yes.
And in the state of Wisconsin?
Yes.
And where is 1B in relation to the other apartments in the building?
It would be the northwest apartment.
Corner.
So of the 8 apartments, it's on the first level, northwest apartment.
So it's first level, and is it closest to the main doors that face the parking area on its side?
Yes.
Okay. And then there would be a second floor of apartments?
Correct.
So if I understand correctly, 1B would have an apartment directly above it?
Correct.
And it would have an apartment across from it?
Correct.
And then it would have an apartment on the side of it as well?
Hey, Monica, we're catching up. We'll be live here in just a little bit.
Yes.
Maybe tomorrow. We're just trying
when
to catch
you were
up since
there
this
that day,
case was ahead
what
of
can
us
you
by a couple
say
days.
about the weather conditions that were being experienced?
We had received a substantial amount of rain, so everything was wet. It was gloomy, cooler.
You say substantial amount of rain. Just a short rain, a Wisconsin short rainstorm, or something larger?
No, it would have been days of rain.
And had that rain been going for multiple days before you arrived at the apartment on the 19th of May?
Yes.
Heavy rain?
A substantial amount of rain, very heavy.
Thank you. So when you got there, Detective, you arrived, there were already officers on scene. You indicate you speak to a person who identifies herself as Sadie Beecham, and she's located by her car. Is that correct?
That's correct.
Is it still raining outside in your memory?
I don't recall. I know it wasn't a downpour. If it was raining, it may have been sprinkling.
Okay. And at that point, what, if anything, did you notice about the demeanor of Sadie Beecham?
She was scared. She was visibly shaking.
That was Sadie there on the left.
Having a difficult time spitting out words. Frightened, worried.
Could you tell what she was scared about in general?
I'm going to object speculation.
What, if anything, led you to conclusions that she was scared, other than these early physical observations?
I'm going to object again as to speculation to how his conclusions that she was scared.
People don't talk the way lawyers want them to. Lawyers are taught that the witnesses are to testify only to things that they perceive with their senses. I saw this, I heard this. That's not the way people converse in ordinary discourse. They combine their observations with the impressions that they personally have formed, which do often involve some degree of speculation, and sometimes involve
he's just speaking to the jury here,
making suppositions about what others are thinking. That's not how we talk in ordinary discourse, but when we get into the courtroom, the lawyers want to pin it down to exactly what the witness personally knows, what the witness has perceived.
It's not that
with
lawyers
his
want
own
to,
senses.
it's what's admissible.
But what the question is calling for is really a composite of what the detective personally observed and somewhat the conclusions, and they're suppositions as to what may have triggered the response that he was seeing with his senses. So I'm actually going to allow the answer, even though it does incorporate some of that, so long as you folks understand that there's going to be some supposition, and it can be dealt with further on cross-examination. But there will be some supposition built in, and not things that he actually has
So the
observed.
state takes the lead on the judge's rulings, 2-1.
No, I'd like it repeated, please.
It's the third
So
time.
you've indicated she was shaking. You
Yes.
made a physical observation that she appeared frightened.
Yes.
Any other observations or information lead you to conclude she was frightened other than that physical observation you've testified to so far?
Yes.
And what was that?
She was concerned about her children.
I'm going to object. This answer is hearsay.
It's supposition.
I'd briefly like to be heard.
Well, I didn't say.
Okay.
Now,
Get
see, I'm
spicy.
supposing what you're thinking.
Wait,
And
I
bet
believe
I'm
you
right.
are. I believe you are.
I'm right.
Yep.
And we can have that discussion separately if and when you ask the question. But in terms of this particular question, it is not that it's hearsay, it's that it's supposition. So I'm going to sustain the objection.
All right. I'm going to head the direction you are anticipating now then, Your Honor. So, Officer, at the time that you first spoke to Sadie Beecham and she provided you information, was she physically shaking?
Yes.
And did she show signs to you that she was still experiencing emotion as she was speaking to you about what she was telling you?
Yes.
Would you describe her way of expressing herself as calm or excited or distressed? What would be your explanation of the phrasing and wording and tone of her discussion with you at this stage in your contact?
She was truly scared of, petrified about what had happened.
Judge, I'm going to indicate to the court that this is an excited utterance and ask the court to allow admission of anything that was during the physical observation.
That's a way to get around hearsay.
And Judge, I would object. This witness has already testified that he was not the first individual on scene, so that there were other individuals who had spoken with Ms. Beecham prior to this. Several time had passed. Also, excited utterance has to deal with that immediate impression. Nothing was ongoing at that time. The defense would maintain that given the time that had passed and the time that had passed since she had made these observations, any subsequent statements made to Detective Anschutz, it does not fall under the excited utterance exception to the hearsay rule.
Well, let's begin. First of all, it's not my impression that they're actually being offered to prove the truth of what is asserted in the statement. I don't think the district attorney is offering this prove the content of the statement, which is asserted. Second, it's a non-testimonial statement, so we don't have that concern. To the extent that it would qualify as a definitionally hearsay statement, it is, I think, an excited utterance. the law with respect to excited utterances, the key is not, for example, the passage of time or the intervention of others. It's the spontaneity of the statement which is made. And given the situation that existed as portrayed in the testimony, I'm going to overrule your objection.
So 3-2.
What did she say?
I guess the couple of things, Judge, just if I maybe heard. First, we haven't heard what the statement even is.
Yeah, that's correct.
And second, if the state's premising their question that they're seeking to introduce the statement under the excited utterance hearsay exception, then they must be offering it for some sort of truth, or else they wouldn't need a hearsay exception.
Well, you're right, and that's why I led off actually starting with the confrontation, or actually I actually started in my analysis with whether it's even subject to those rules, because it's excluded from the operation of the hearsay rule. So I would not even accept the premise that he needs an exception to get it out of the hearsay rule. But I understand your point, but I'm going to overrule the objection. Go ahead.
So my question is, what did she say to you when she was in the condition you have described?
She had told me she got to the apartment, observed the screen door closed, but the glass door opened. She looked inside, saw blood everywhere, and walked out. She said she was frightened for her children because she knew Zach Anderson had something to do with this. And
Judge, I'm going to object at this point and ask that be struck.
Judge, this is all during what she said during the examination. She's going to testify. This is subject to cross-examination. The officer should be allowed to finish saying what she told him on the scene in this excited state and not be interrupted unless there's a new objection. The court's already ruled that in that state she can say this.
Well, I've ruled that when she's in this state she can state things that would be normally reactive to a situation in which she found herself, but now she's getting into her analysis and there's actually another rule, which is the present mental state, purpose or plan, which probably would give some relief to the district attorney. But the problem with the testimony is it's reaching into the ultimate facts of the case, and it is relayed testimony for a witness who's available to testify, and correctly you state she's going to be subject to cross-examination, but it's not as it's her opinion about the
it's the judge's phone.
What she's concerned about is
the detective's bursting out laughing there. He's covering his face.
Inadmissible. It's irrelevant what she thinks.
She expresses a alarm to officers.
Yes.
I think that typically a person who has observed a crime scene is allowed to tell an officer.
I don't want to talk about typical.
Oh, okay. Well, so in this case, she arrives at a crime scene. She has an abundance of evidence that, of course, is not in this case so far, right? But she has an abundance of information. She is in a highly frightened condition, according to the officer, and she expresses fear for her children because of something specific. I don't think any of that's irrelevant, nor is it hearsay.
The problem is that. Starting with the testimonial nature of it, it's still not. But we're getting to the point where you're getting into what should come in, if it's going to come in at all, as testimonial. She's not subject at this point to cross-examination. So I'm going to sustain the objection.
Okay, so I'm counting three.
After she expressed fear for her children, what happened next in relation to Sadie Beecham?
Due to her concern for the children, she.
We've got to move on to the next step because he's incorporated the objectionable material into the beginning of his next answer. So just what happened next is the question.
Sadie left to check on her children.
And after that, did you then take it upon yourself to be part of an entrance into the residence?
I did.
Okay. Up until that point, what had you done in relation to the residence, if anything?
I peered in the sliding window, didn't enter, and I also walked into the hallway through the front entrance and looked around in the hallway.
I'm going to now show you what's been marked as Exhibit 1 in this case.
State's Exhibit 1, Photo 1.
State's Exhibit 1, Photo 1. It's going to come up on the screen up there. I'm going to ask you if you recognize...
Judge, I'm going to ask that it not be published for the jury before it's been admitted. That it needs to be shown to this witness first, not in front of the...
Well...
Let me talk to counsel briefly about that. Just
okay,
so that,
I will
so
say...
that she understands at least what I'm talking about.
Okay, and based on the electronic experience we've been having this morning, it may not show up on the screen anyway.
Adam? Paging Adam? Yeah, she's right. You shouldn't show something when you haven't laid the foundation. You shouldn't show it to the jury. It has not been admitted as an evidence. The jury should not be seen it to consider it. So she's got a good objection, but there might be a technical explanation for what they're doing. She doesn't miss anything. She is a top lawyer. She is very good.
Her objection, but she's first asking that I read a stipulation. This is a stipulation that we have previously provided the court, and it's about the admission of evidence that comes in either pictures or downloads. If I have your permission to read that stipulation to the court?
You may do so.
So this says the below signed parties stipulate. It's signed by both myself and Attorney Miller. It indicates the below signed parties stipulate that all photographs, financial records, phone records, social media records, computer downloads, and phone downloads be admitted into evidence without foundation testimony. The purpose of this stipulation is to allow all parties to discuss and question witnesses regarding these records without having to previously set a foundation. So essentially what we are doing, Judge, is we're stipulating that, oftentimes in a courtroom we have to bring in somebody to say who took the photo or how was the photo compiled. There's additional witnesses or additional time. We're just going to seamlessly show those records as long as we make sure each other are apprised to try to save that time, because there's an enormous amount of records and photographs, as the court is aware. Is that true, counsel?
That is true, and I just thought it was appropriate to read that stipulation prior to it being shown to the jury, so there was that understanding and the record. But any objection to it being shown now is withdrawn now that that stipulation's been read.
Thank you. All right. Best.
Again, I'm going to show, Detective, I'm going to ask you to turn your attention to the television that's above the jury and look at State's Exhibit 1, Photo 1.
There might be a little bit of blood here, just heads up.
Assuming that it works.
I think we get to see some of these pictures. I'm not sure if we get to see this
Judge,
one.
does your laser pointer work on
television? It doesn't work on the glass.
Okay.
But I do have...
you have the old school?
I have Sister Marcianne's... where is it?
A ruler. We need a ruler. Or a dowel stick.
Many's the time. It's not going to come on? Oh.
Okay, I will warn you, this crime scene is pretty gruesome. I don't remember when the picture's shown. I'm not sure if it's today or another day, but
okay.
There's no bodies.
Works perfectly and seamlessly.
There's a lot of Kool-Aid.
Yes, indeed.
Yeah. All right. So
if he's going to be using the pointer, maybe we'll give him a mic. Let's hope we've got power in this.
So, Detective, as you look at this, do you recall what this is a picture of, or know this picture contemporaneous with what we've talked about, May 19th, 2020?
So this would be a picture of the north side of 3709 15th Street from the parking lot, looking at the entrance to the residence.
The residence we've talked about, apartment 1B?
Correct.
And can you tell by the conditions of the vehicles and the roadway there what the weather conditions are at the moment these pictures are being taken?
It's either raining or had rained.
Is there? Do you see a white larger vehicle that's prominent in the center of picture 1?
Yeah. Should I point?
Yes.
This one?
I'm referring to that vehicle. Do you recognize that vehicle in the context of this investigation?
I do.
Okay. And what is that vehicle?
That's a white Ford Explorer, Colorado plates, that was belonged to Rosalio Gutierrez.
Okay. And is that the individual who you believe to reside in apartment 1B?
Yes.
Is Rosalio's sliding doors, in other words, a non-hallway entrance to his apartment or exit to his apartment, is that visible in this picture?
Yes, it is.
And can you point out where that is located within this picture? Okay. And there appears to be a yellow sort of tape or rope that is located in this picture as well. Do you see that?
Yes, that's crime scene tape.
Okay. Is that in a couple of locations in this picture?
Yes.
Can you point out again with your pointer where that is?
There's some here, stretched, and then some from the entry door to 3709, stretched out towards the parking lot.
And based on your knowledge of these investigations, who put that up? In general?
Usually the responding officers will area off so no one comes or goes.
This is after they make their initial assessment of safety and security?
Correct.
Okay. And so at the point that you have finished speaking to Sadie Beecham initially, is this the vantage point, or is this the view you are seeing back on May 19th?
Yes, that's accurate.
I'm going to show you now what's been marked as picture 2 of Exhibit 1. Do you see that picture as well and recognize that?
I do.
What is that a picture of?
So this is the main entrance to 3709. This would be the sliding screen door, glass door to apartment 1B, which is just inside the door to the right.
And do you recall whether the overall building that where you see this door here, is that a locked door or is that an unlocked door to get into the main hallway?
That is unlocked door. There's also a door on the other side of the building that you can enter this hallway that is also unlocked.
Okay, so at this period of time, this apartment complex did not have locked doors into their central hallway.
Correct.
And what would you estimate is the distance from the Rosalio Gutierrez sliding door that we can see there onto that small patio, and then down to a vehicle parked directly parallel below? How many feet would you say that is, or however you want to estimate the distance?
25 to 30 feet.
Okay. And much of it is grass?
Yeah, there was a small concrete stoop, and the rest grass, then sidewalk.
And of course, the sidewalk and the patio would be probably concrete?
Yeah.
All right. Now I'm going to show you what's been marked as Exhibit 3. Again, is that something you recognize again from May 19th, 2020?
Yes, this is going to be the front entrance door to 3709 15th Street. This would be the sliding glass door to apartment 1B.
So it's a different vantage point a little closer up?
Correct.
Now I'm going to show you what's been marked as Picture 4, Exhibit 1. Do you recognize where that is located on May 19th, if you do?
Yes, so when you enter that main entrance door that you just saw in the last photo, there's a stairway leading to the upper section of the apartment complex, and this would be immediately to your right underneath the stairwell. This is the door to apartment 1B.
So as I look at Picture 4, can you orient me on either direction where that front entrance hallway to the hallway is? Is it further down the hallway, or is it off to the, I guess would be the right of the exhibit?
I'm sorry.
The main doorway we saw in Exhibit 3 that takes you into the hall.
Okay.
Where's that located vis-a-vis this picture?
So this photo is taken just inside that main entrance to 3709.
Okay. So essentially this is taken in the doorway of the entrance we saw in Picture 3?
Yes.
Okay. And so how many feet, again, would you estimate it is to go from that doorway entrance to the doorway of 1B?
10 to 15 feet.
Okay. And there's a stairwell there?
Correct.
If a person wished to, could they ring the doorbell or knock on the door at 1B and be able to stand or crouch to one side or the other of that door? Is there room to do that?
Yes.
And where is there room to do that depicted on this picture, if it is?
So this is a small hallway or a small wall that extends out. If you were to go around to the other side of this, you wouldn't be seen. You also could back up to where the photo was taken and not be seen. And also there's a void here underneath the stairwell that you could stand or crouch under the stairwell and not be seen.
Are the metallic objects to the right of the door depicted on this picture, are those mailboxes?
Yes, those are the mailboxes for the 4 lower units. These are for the 4 upper units.
And based on how high up the stairwell is, if you can estimate, does a person have to sit down to be able to get to their mail, or if by bending or standing, are they able to reach their mailboxes in this picture?
No, you're able to walk up to it and get that mail.
Hey, Tag, you
If
haven't
you
missed
know,
much.
apartment 1B,
This is the first witness.
does that door open, again, only if you know, does it open into the hallway or into the interior of the apartment, if you recall?
It opens in to the apartment.
So, and did it have a doorbell of some kind, if you recall?
Not in the hallway here.
Okay. So, if a person knocked on this door and then did not become visible, is there one of those eye holes so that from inside you're able to see into the hallway?
Yes, there's a eye hole.
Okay. So if you
I've
kept
got him
yourself
talking
off to the side so you were
1.25
not
speed.
visible in the eye hole, the door opens back into the apartment if somebody is inside and they are opening the door to see who knocked. Is that correct?
Yes.
And until somebody peeked out, in other words, brought their head out of their apartment,
They pulled their head out.
that area by the mailboxes would not be visible to them until they somehow extended their head out into the apartment or took a severe angle after opening the door. Is that right?
I'm going to object as far as foundation, this witness's knowledge of whether that's possible and whether he attempted to do that himself.
I think he can make estimates based on his observation and how the door works. I mean, he's a physical observer. He's an eyewitness.
I think it's subject to analysis as something that he can perceive without any particular expertise.
This guy flaps his right arm.
That of the ordinary layperson, but it's his description of it makes it more makes it easier for the jury to understand. Objections overruled.
Did you understand my question?
Go again. Sorry.
Sure.
4 to 3.
If somebody is crouching or attempting not to be seen and they're in the area of the mailboxes, okay, and they knock on the door, and the person inside 1B opens that door to be able to see somebody over by the mailboxes, would they have to poke their head out?
So I would say you would have to break the threshold of the door. We train on clearing room clearing in law enforcement. And in order to see up against this wall, we have to break the threshold. That's one of our main concerns when we clear rooms before we enter them, is a blind spot up against the wall right here. We can pie the room off all we want, but we can't see this. Even if we're standing way on the other side of this door, looking on an angle, we can't see against the wall. And that's our main concern when we enter rooms, because we can see the whole room except for tight against the wall.
When you say clear a room, does that mean to try to figure out if there's danger to you in that next room?
Correct.
And would that danger include a person having a weapon?
Yes.
And do weapons include everything from guns or knives to clubs or hard objects that could hit you?
Correct.
Okay. So when you clear a room, you're worried about all of those possible threats in the possession of a person who might be crouching. Is that right?
Yes.
So did you, before you entered the rest of the apartment, were you able to make observations that concerned you at the location we're talking about? In other words, then, the door and the hallway that we're in right now. Were there observations that you, as an officer of this extended period of time, having been to scenes with blood before, did you make observations that concerned you before you entered?
Yes. I see what appeared to be blood here. And that blood was running down the wall, down the door frame.
Judge, I guess I'm going to object to his answer saying that it's blood.
He didn't say it was blood. He said it appeared to be blood.
And, you know, Judge, this is a person whose credibility on this issue is that he's been to what he told you was hundreds of crime scenes over a period of more than a decade.
We're arguing about something that's not up because I didn't.
Yeah.
The witness did not say it was blood. The witness said it appeared to be blood. So you're safe.
Okay.
All right.
Should I go on then?
I'm going to count that for the state.
Crouching.
Excuse me?
But I'm crouching.
Officer, did you see anything else that caused you concern at this specific location in those early observations?
Yes, there was blood, what appeared to be blood on the door. There was also what appeared to be blood on a mailbox, the wall, the door, and the mailbox.
And then ultimately, did you enter the crime scene?
I did.
And do you recall what way you entered the crime scene? We've seen 2 entrances, the hallway and the sliders. Which one did you go in, if you remember?
We entered through the through the sliding door.
Okay. Do you recall when you ultimately, if you know, do you recall whether this door was locked from the interior or not? Only if you recall.
Yes, this door was locked from the interior.
When you arrived at the scene?
Correct.
Okay. So when you entered, did you take any steps to try to be a steward of the evidence that was in, any evidence that might be involved in that scene?
So at the time, it was the utmost importance preserving evidence on the scene. I wore booties over the top of my shoes. I wore a mask. I wore gloves. I didn't have anything with me.
Do you know how you make sure you don't track evidence out of the room when you're doing that?
So
you lift up
when you
one foot
walked
and you
in, do
shake
you
your
recall
booty.
who went in with you, if anyone?
Detective Correa.
Just to stop you, is Detective Correa the individual seated in the here at council table with us?
In the gray suit.
Okay. Who else, if anyone?
Officer Widener and Officer Van Wee.
And do Officer Widener and Van Wee have a particular reason that they would be accompanying you within the Kenosha Police Department? Are they detectives?
No, they're highly trained in processing evidence. They're specialized in that, retrieving evidence.
So let me just ask you, to the extent you know, that's a specialty in a police department?
Yes.
That requires additional training, extra training?
Large amounts of training.
And do you know, if, in your experience, are Officer, did you say Van Wee?
Yep.
And Widener, are these brand new officers who have just started the evidence collection, if you know?
No, they're both seasoned officers who've been on longer than me, 20 years. And they have been processing evidence scenes for the vast majority of their time at the police department.
Is that why they would be sent to a scene like this one, in your opinion?
I think he
Correct.
just swallowed his
we
gum.
have.
Okay. So why are they, was it a surprise that they were coming in with you, or does that make sense to you in the context of what this investigation is? Describe for the jury how come there are 4 officers coming in now. We know some officers have already been in there. They have a different role. What's going on now?
So we walked in, Detective Correa and I were the investigators on the case. Van Wee and Widener were there specifically for evidence collection. So while we were in there, we communicated with each other what was seen, thoughts on what happened, and ultimately, you know, we picked up on things, they picked up on things, and then they completely, thoroughly process the scene.
I think that's a wand he's using.
If I said that this sounds like it was a walkthrough,
Like
is
a
that a
magic
word, a
wand.
phrase that you're aware of, or a term?
Yes.
And is that what
Nothing,
you just...
nothing was collected at that time. We simply walked through to get an idea of what had happened there to further our investigation.
So, if I understand, it's not your role to pick up individual pieces of evidence. Is that right?
No, that would have been entirely up to Widener and Van Wee.
You're making observations to see what to do next.
Correct.
Okay. Do you observe any electronic items that are on that would at least cause you to note that in terms of, you know, why this scene would be where it is? Were there any electronic items on?
Yeah, there's a large television that had a blue screen with Rosalio, the name Rosalio.
I'm going to show you what's been marked as Stakes Exhibit 150 and ask if you recognize that. This is, again, Exhibit 1, Your Honor, Picture 150. I apologize. I'm always mean. If I say 150, I mean the picture 150.
This is the television.
He looks so much like Steve Martin from the side.
So Exhibit 1, Picture 150. Does that depict what you have just described?
Yes.
All right. And so that's a television, I assume, that we see that has the blue screen?
Yes.
Okay. And you indicated it has Rosalio. Can you just point that out with the pointer, please?
Yeah, it appears to be in like a standby mode.
Okay. Now, it looks like the TV screen is above a cabinet or shelving that is fairly extensive in the room. Does that appear to be an accurate depiction of what you saw on the 19th?
Yes, this was on the west wall of the living room area.
All right, and I'll show you a diagram in a minute, have you point out where on the diagram. But before I do that, is there any evidence that anything has been disturbed in this? It looks like, I mean, is this a cabinet, or is this a bunch of shelving, or do you recall? If you know.
Both, I guess. I mean,
Okay.
it's cabinet with shelving.
I'm slowing him down here to regular speed.
Like an entertainment
Okay.
stand, have you?
Does it
Everyone's
look like
blood
any
pressure
items
was
have been
going through the roof,
toppled from this, or are disturbed in any kind of major way?
Not majorly disturbed. However, there were some items laying on the ground that may have been knocked off that I don't know.
And were there any, as to this cabinet or this set of items, if you recall, did you make any observations about anything on this item? Only if you remember.
Yeah, there was blood spatter on the photos, photo frames, basically throughout.
Okay. All right, I'm going to show you.
Judge, again, I'm going to ask that that be struck as far as that it was blood splatter.
There's not a foundation for the witness to identify the substance which he observed as blood. So unless I'm corrected, we're going to interpret that as it appeared to be blood.
Appeared to be blood to me.
Okay.
Judge, I just would like to approach just briefly. If we could just talk about this very briefly.
As you wish.
Okay, I'm going to say that was cited for the defense. I'm showing 5-4. I think it's 5-4 on that. And now we finally returned to some good old approach the bench situations. Judge has his head in his hands. I'm not sure if that's like his default listening position. But everyone's mentioning the nails. I have not seen her nails. I have not looked once. Does she have like super long nails? It could be splattered with spatter, potentially. Or, Ed, it's possible it could be dyed batter as well. Judge is on half speed. He's always a little bit on the slow side. She's got Cruella de Vil nails. So 5-4, that's my current count as well, DMB. Appreciate you keeping track. I might miss a couple, so if you can count, that would be interesting. We do want to see if he's calling it fair, or if it appears. I mean, obviously, just because one side gets a ruling, then the other side gets a ruling, doesn't mean it's being called fair. Something you said was funny right now, but we'll never know, apparently. Waiting for the audio to come back on. It's possible that one side just commits all the fouls, and then he rules always on the other side. But the lady right there who's laughing, that's the girlfriend. It was her boyfriend that, her ex-boyfriend was the defendant, and then the boyfriend after that was the one that got unalived, and the body has not been found. Well, we presumably unalived. I believe the state has ruled that he's died with absence of body. Let's see. Judge looks how I feel. He's listening hard. Possible migraine. I don't know who's behind. This is obviously the state side. So I think that's family next to there on the front row, and maybe friends behind. Her gross nails. She has talons. There's no audience. It's very quiet. I bet that the further we go in this trial, the more that courtroom's going to fill up a little bit, because the back and forth, the debate back and forth is great. I love it. I love the action between the lawyers. Sounds like the
officer.
The state
you just stated that an area was blood. There were some droplets there. You're not saying that you are aware that there's been some professional confirmation that it was blood. Is that correct?
That's correct. It appeared to be blood.
Okay. So when you say blood in this context, you're stating your opinion as a professional police officer based on your training and experience. Is that correct?
Correct. From now on, I'll say appeared to be blood.
But you're not saying that you did any kind of professional analysis. You're simply saying, based on what I do for a living, I'm offering you the opinion that's blood. Is that true?
Yes.
Okay. So I'm going to show you a diagram of...
He's offering the opinion that it appeared to be blood. Yeah. And I would add what I said before about people in ordinary discourse had some degree of supposition and personal, or not personal knowledge, but historical experience into their answers. So if he does slip into saying blood. Keep in mind that is not definitively proved. It's his opinion under all the circumstances and what it appeared to him to be. He's saying it looked like blood, but when he goes back to the police station.
Okay, anytime the judge does this, I need somebody to volunteer a 3-word explanation that the judge could have used instead of the 5-minute soliloquy.
Any question about that? So there is some degree of lack of actual knowledge, and I'm gathering that this will be addressed further during the trial. So go ahead.
So now what I'm going to show you, Detective, is State's Exhibit 41, and ask you if you recognize what this not-to-scale diagram is of. This requires us to change machines, Judge, so we just need the patience of the jury. So.
And Doug. We need Doug. The judge is very smart. You've got to give him that. He's got a lot of experience. He understands the law very well.
Can you expand out as large as you can, but still have the exhibit sticker, please? That's as far as it goes? Okay. All right. Please take a close look at Exhibit 41 for us and indicate if that appears to be a diagram of a layout, again, not to scale, that you recognize.
Yes, it's a very rough sketch of the apartment.
Does it appear to be basically accurate based on what you recall of your walkthrough at the residence at 1B?
It's a child's
on Exhibit 41, can you just point out for the jury, where is the hallway door that we saw?
It'd be right here.
Okay. And so when you enter that hallway door, what is on each side of you? So what are the first things that are on either side of you in the apartment as you enter?
My kid could do a better job than this.
If you remember.
Coming through this door.
Yep, the hallway door.
So to the right, this way, would be, there was a couch.
Abracadabra.
And does it appear to be an L-shaped couch?
Yes, it was an L-shaped couch.
Okay, and then what else?
There was a mat standing up. And then to the left was a kitchen area. But I recall there being a wall or something here. Okay. I'm not 100% certain.
Okay. That's what happens when you first enter, correct?
Yes.
And is there a dining room table area?
Yes, this would be the kitchen. This would be the dining room area here. Dining room
They
table.
spent all their money on
and the rest of that
witnesses.
then, including where the couch is the living room area?
Not drafting.
Correct.
Okay.
This whole area would be the living room area here.
Where's the TV that we just saw located on this diagram?
Against the west wall.
Okay.
On the west wall.
And then where are those slider doors that we just saw that would bring you out by the street?
So the slider entrance is right here.
Okay. So when you entered, you said you entered the slider door, correct?
Correct.
And then if you enter that door off to the right, you see the TV that we already showed a picture of, correct?
Correct. The cabinet in the television photo that you saw would have been taken from similar to this.
All right. Okay. Now, you're not the evidence person, so I'm not asking you for specific and sort of honed in detail, but as you enter the slider doors, what is it that you observe that causes you concern, if anything?
So as soon as I walked in, I observed a substantial amount of blood right here.
And located on what?
So it would have been on the carpet, pooling of blood. So within that pooling of blood, there was an obvious void where there was no blood in the shape of a rectangle. So substantial amount of blood right here, and then a void, as if there was like a rug there that had been moved after someone was bleeding.
What else did you observe? that caused you any concern?
That's a good analogy.
I observed
as if there had been a rug.
Significant amount of suspected blood on this table, on the couch, on the walls, on the ceiling, on this wall, on the cabinet, on the floor throughout here, on the back wall,
So,
and some areas in the kitchen here.
So, Detective, you sound like you're describing many locations in multiple rooms. Is that what you're intending to tell us?
There was suspected blood throughout.
Okay. And some of that's on the ground?
Yes.
And some of it on the ground is substantial?
Yes.
Okay, a lot?
Yes.
And some of it is on the walls?
Yes.
And it's not just one wall, it's several walls in the residence?
Yes.
And some of it's on the ceiling?
Yes.
And it's on the ceiling in several areas of the residence?
Yes.
What about the couch area? Did you observe any blood in that area or anything that, I'm sorry, again, that in your opinion was blood?
Yeah, so the couch had like droplets of suspected blood throughout it. However, against the backrest of the couch right about here, there was a large amount of blood up
Is
where
that a drumstick?
You would put your head.
Is he using a
up
drumstick
towards
to
the
point?
top of the rear cushion of the couch?
I think it's a drumstick, and it's not a wand. Otherwise, like magic would have occurred by now with how much he's been waving it around.
Okay. Do you?
The blood does end up getting tested.
Let me ask you about some specific pictures now, and just orient me as to the diagram. So you mentioned a couch, and you've pointed out that's the L-shaped object. Is that correct?
Yes, right here.
Okay. And then you mentioned that there was a table and a wall area that was over close to where the kitchen area starts, correct? Over sort of across from the couch. So now I'm going to show you what's been marked as State's Exhibit 155.
I think we're going straight from kindergarten drawing to bloody crime scene photos, so just be ready for that. Bless you.
Not 155, 55.
55?
Yeah.
State 1, number
State 1.
Yep,
55,
no, that's fine.
not
You're
155.
Hey, Stephanie Willis. Thanks for being here. Hope you enjoy it. We are catching up. This happened a little bit. This happened last week. We're just catching up. We'll be, once we're all caught up, we'll be playing this really live as it goes. But right now, we're just catching up on this trial.
Based on your observation of the scene at 1B, do you recognize this picture as something you observed in the period on May 19th when you were in the residence, late morning, early afternoon?
Who mounts their bike?
That appears to be taken right
like
as
that.
you enter into through the sliding
it's like a
door.
trophy bike.
Yes.
Okay, so is there a door depicted in photo 55?
Yeah. This door right here would be the door that enters into the hallway.
Okay. And then you indicated there was a couch and that you recall a wall and a table. Is the wall and the table that you recall depicted in picture 55?
This wall.
Okay.
Here, there's a small table.
Okay. And was that an area of concern for you in terms of your observations?
Yes.
Why?
There appeared to be a substantial amount of blood on it.
Then I can see some areas that appear to be staining on a carpet or rug. Do you see the areas that are depicted on this picture? Okay. Now, you indicated in your testimony there was an area on the floor that you saw a substantial amount of what, in your opinion, was blood. Is that an area depicted in Exhibit 55?
Yeah, I had mentioned the pooling of blood on the floor. This is the pooling of blood I was talking about right here.
Okay. And there are other reddish or brown stains at many locations on this carpet. Is that consistent with what you saw that day?
Yes, it was everywhere.
Okay. And do you have an opinion as to what that was in the context of everything else you saw and know from this investigation?
It appeared to be blood.
Now, you've indicated a couch, L-shaped couch. Is that depicted in picture 55?
Yes, so this is going to be the front side of that L-shaped couch with the back of it coming out this way.
And if we go to the right side of this picture, okay, so past where the bike is, where are we in the house or the apartment at that point? Just to orient us.
So directly to the right of whoever took the photo is going to be the television stand. And then there's a hallway right here that leads down to the bathroom and bedroom.
Okay. So we haven't talked yet about the bathroom and bedroom, and that was on that diagram. It's on the other end of that apartment, correct?
Correct.
Was there anything that caused you any concern that you remember in the bathroom?
No.
How about in the bedroom?
No.
Was there only one bedroom?
Yes.
Okay. So those two areas appear to you to be untouched, as best you could tell?
Clean, yes.
Okay.
This was the victim's apartment.
Now, I'm going to turn your attention from Exhibit 55 to number 220, picture 220.
So that's the brother and son.
Is 220 a vantage point or a picture that you recall from the 19th of May?
Yeah, so this photo would be standing over top of the L-shaped couch with one side of the couch going this way, the other side of the couch going this way. When I mentioned what appeared to be blood on the back cushion, this is what I was talking about.
And how would you characterize that? Was that just a small amount or a substantial amount? What in your opinion, what is that?
There was a substantial amount of blood. This wasn't just a spray. It was a large amount of blood.
And then what is the object that's located on that couch that we can see sort of in the center of Exhibit 220 or Picture 220?
So that's a wallet.
Okay. And pursuant to your investigation, did you come to believe that that was Rosalio Gutierrez's wallet?
Yes.
At this time, was his phone located at this time period, if you know?
No, we did not locate a phone initially.
What about his credit cards?
I don't recall.
Okay. Did you, at some point in the afternoon hours, you can go back to your desk, apologize. Did you, at some point in the afternoon hours, come into contact with another individual who arrived on the scene and appeared to know Rosalio Gutierrez?
Yes.
And if you recall, about when was that?
It was about 2:30 p.m.
So you had been there almost 3 hours?
Yes.
And officers had been there for that period as well? You weren't the first there.
Right.
So when Mr. Campbell arrived, he had not been called to the scene, to your knowledge?
No.
When he arrived, did you speak to him?
Myself and Detective Correa did, correct.
And what, if anything, can you say about his demeanor when he arrived at the scene?
He was extremely worried, concerned about the welfare of Rosalio.
How did he know to arrive, if you know?
Objection calls for speculation and hearsay.
That was one for the defense.
Let's see, how do I rephrase that? Pursuant to your investigation, did you come to have an idea how Michael Campbell knew to arrive at the scene?
Yes.
And what was that?
I'm going to object.
Same
It
objection.
honestly calls for double hearsay, Judge.
You have an idea. That covers a lot of turf.
Yeah, it's really not for the truth of the matter. It's simply to orient how this person arrives there and sort of what happens
Look at
next.
this. It's not for the truth of the matter.
If it's not for the truth of the matter, then
It's not relevant.
usually not relevant.
Well,
I think let's go into the defense again.
when you said Mr. Campbell was highly concerned, what else can you say about what your observations were of his physical state when you saw him?
He was worried. He said that Rosalio was a...
Why don't you rephrase your question? Well, we're getting into a lot of supposition, and I just think I've caught the scent of some real hearsay.
Objection from the judge. I don't know who to give that to. His mouth, he wants to talk. But then nothing
Based
comes
on
out.
the demeanor of Mr. Campbell, what happened next? So you saw him. Did you ask him some questions? I'm not asking the answers. Did you ask him some questions?
I did.
And what was your impression of his level of cooperation or forthcomingness in terms of your experience as a police officer and investigator having arrived at the scene?
My impression of Mr. Campbell was that he was concerned for a close friend of his who he hadn't heard of from in multiple days in a row. He was concerned.
Without talking about without talking about the content of
Judge, I'm going to object and ask that the last comment be struck from the record as far as what he did, what as non-responsive, and also it calls again for hearsay as to what Mr. Campbell said.
It certainly, this is why I was concerned about the scent of hearsay.
They smell similar, Michelle Clark.
Stark,
sorry.
The testimony that the detective has given is, the appearances of whether someone appears anxious. Those are conclusions we all reach in our everyday lives, and that's okay. But when you encounter someone, even under these kind of circumstances, you really don't know what the person was anxious about. And
yes, they do remain seated for questioning.
He reports what the other person said. If he's relating what was actually stated by the person, that qualifies as hearsay, generally. And then the impression that the detective has expressed, which is his conclusion from the whole incident, includes not only the hearsay, but also his own conclusion from it. And as I say, in our everyday lives, that is how thoughts are expressed, but it's not admissible in court, so I'm going to sustain the objection.
All right, one more for the defense.
So I just want to approach briefly again, Judge.
I'll tell you what.
Got 7 to 5.
You'll probably be shocked that the Court of Appeals just doesn't automatically conclude that everything I do is right. They want, when there are discussions about evidence, they really want them taken down so they can see what I was thinking when I made a ruling on it. So
I don't think they got that far.
If you want me to re-examine that issue, you're welcome to say so, and why. On the record.
Yeah, so clearly one of the themes for the defense, you're asking me to do it now, is if I understood the court correctly.
It was my impression, now here, I'm in the conclusion business too. It was my impression that you felt that the ruling was not exactly correct.
I thought I had additional information that might assist the court in terms of where I was going.
Morning break yet, did we? And I promised the jury. Let's take a break and then I'll chat with these people for a minute. Please don't talk about the case during the break.
Okay, we are not quite caught up. Let's see. By not quite caught up, we're still a full day behind, but we're cutting out all their lunch breaks and their rest breaks and things like that, and we're catching up. We're also using some high speed, like 1.25 speed on the playback. So we're trying to get caught up here because they had like 2 days of testimony. By the end of today, we will have played 3 days in 1 day. So we're getting caught up. We will be caught up this week, and we'll be caught up to live and be able to watch it live as it happens. But
and there's some right around the corner too.
Yeah, the breaks will help us catch
people like
up.
me who actually drink tap water, as long as it's not from
Who would do that? Yuck.
New Palestine.
as long as it's not from New Palestine. I don't have tap water. I've got Deer Park water in my my pink mug today. And it tastes delicious. The sound guy doesn't know if he should leave the sound up or down. So the judge sort of just like dribbles off.
Investigating in several aspects of this case. We have Mr. Campbell arriving at the scene without explanation, and we have certainly the defense has suggested that certain other things should have been investigated. I believe that the detective would be able to provide a factual circumstance as to why he did not proceed to begin to investigate Mr. Campbell and was instead oriented in other directions. Obviously, why officers conducted themselves at each point in this investigation is of direct relevance. That was really the theme of the defense opening here. And so I'm not suggesting, Michael Campbell's testifying, right? So again, it's going to be subject to cross-examination. But what information was shared with the detective that caused the detective to have no concern about the fact that Michael Campbell had shown up at this scene, from my perspective, is relevant to describe what the motivation of the officer is or why the officer did what he did next, which is in this case, did not believe that Michael Campbell was worthy of additional investigation or follow-up based on that moment, based on that incident. So again, it's all about the police investigation and what motivates them to do each thing, because that's, of course, been put into direct question. Thank you.
Just because there's a defense theory or theme in place and that it may address Michael Campbell doesn't mean that the hearsay rules and the rules of evidence don't apply.
Well, I'm not a camel. I think what he's saying is that what he's seeking is not being offered to prove the truth of the matter asserted, which would make it non-hearsay.
But then why is he looking to offer it?
Because it disproves something to which you opened the door.
But I don't have to prove or disprove anything. So if he's looking to use that to provide an explanation, then it might not be the truth of the matter asserted for simply that point, but it is the truth of the matter asserted for then why law enforcement did or didn't do something.
No, but that's not the assertion. The assertion is the content of what Mr. Campbell said. That's the assertion.
I mean, at the end of the day, Judge, I guess what I'm struggling with understanding here is that if the state's going to continuously ask what another individual said, and it's true that he will be subject to cross-examination, but he's not subject to cross-examination right now. So there should be an order of witnesses that if they intend on using Mr. Campbell's statements to justify further means and ends, then they should have called Michael Campbell to the stand first and then had this officer testify. I'm not sure what rule allows the state to proceed in introducing statements of other witnesses when they are using it to establish why things weren't done. So it is being used for the truth of the matter asserted.
First off, I think that confrontation is off the table. It strikes me it's not testimonial, at least not at this point. I think he's offering it to respond to the accusation that you've made that the police did an inadequate investigation and not to prove the truth of what it is that Mr. Campbell claimed. And that would be true even if Mr. Campbell were not available, but if he's available for cross, then to the extent that there would be any testimonial component or hearsay component, that should be eradicated by his
I've got 7 to 5 for the defense right now.
So
I have nothing further on the issue, Judge.
Okay.
So I just wanted to tell the court that when I inartfully, I think that's the word, right?
It's a word, but I'm not sure it's appropriate.
Well, it's because I'm not far along yet. When I inartfully raised the same theory regarding the utterances of Sadie Beecham, I was doing the same thing. As the court recalls, Sadie Beecham has been specifically mentioned in the opening. And so what she said to the officer about why, for instance, the officers, what the jury knows right now is that the officers heard from her and then they disengaged from her and they walked in the scene. That fits right into the defense theory. You got yourself a suspect right here. What do? You say, see you later. I'm highly paraphrasing.
Heavily litigated. That can't be a suspect.
Finish.
But the point is, if you are trying to point out that officers are doing things in the wrong order, leaving things out, not doing it, then the information that they are receiving that causes them to do it. So in this case, my offer of proof is Sadie Beecham said, I'm terrified that my ex did this, and now I am prioritizing. I am so worried about the safety of my kids, I'm begging you to let me leave to go get my kids safe, and I'll come back. Okay, this is what she said. And so the officers let her do that, and she returns back later that afternoon with her daughter. Okay? So again, what otherwise could be depicted as, you got yourself a witness here, and you just let her leave, and you're not talking to her again for, X number of hours. It's explained by what the officers did, what their information is. So again, I'm not offering it for the truth, and she is going to be back. Sadie Beecham is testifying in this case. What she said to the officer and whether it's legitimate and all those will all be able to be challenged. But that information to the officer is completely relevant to why he makes the decisions he does in terms of the order things happen in this case. Thank you.
Okay.
I have nothing further on the point, Judge.
Well, I think Mr. Gravely has been premature in throwing himself on his sword because I'm just picking up on it now, so I'm the one who didn't catch it right away. And the reason is it's so commonplace for the prosecutor, and not always just the prosecutor, but usually will try to fetch a little bit of extra hearsay out of the police officers by asking for some hearsay-ish information, and then
hearsay-ish.
When there's an objection, say, well, it's just
different than hashish
being used to explain why he acted as he did next. And usually the response to that, as you correctly noted, is it's irrelevant. And it is. But this time, it actually is relevant because of your opening statement. So looking at it that way, it is proper questioning.
Okay, so that one's for the state.
And then I would just ask that if these questions are going to be elicited, then I want to make the record now that I would cross-examine on those statements with this officer prior to the other individual testifying then.
The order in which he calls his witnesses. We talked about risk the other day, and we're back there because if the witness doesn't testify, then there could be an issue, although I think I've made clear I don't think that these are confrontation issues or hearsay issues with this understanding. And so even if the witness ultimately does not testify, I don't think it would cause any problems.
I think, though, in the situation where if they're eliciting testimony of what another witness would say for this purpose, that at the end the defense would seek a curative instruction that the jury should not consider those statements for.
There's a limit to what he's going to be allowed to draw out, and so we need to be aware of that, and I'm sure he is. And if he questions to such an extent that large amounts of information are coming out that indeed become testimonial, then that's another issue altogether. But right now, I think we're still above the level of the water. So let's take.
So that one's for the state.
10 minutes,
That makes us 7 to 6 now.
We'll continue.
Thank you, Your Honor.
Thanks.
Okay, so a little break. A little bit of a break. Let me check my timestamps. We're coming back at 21:17 or 22:17. Okay, this is the last segment. This is approximately about 40 minutes, 45 minutes roughly. That will end our catch-up period on the first 3 days. That will finish day 3. We could start day 4. I haven't pre-watched that, so I don't have the timestamps of where that's at. If you guys want, if we want to go a little bit later today to catch up,
those who
we
are
can do that.
complaining about the room being hot,
You can go to, what did he say? Just kidding. Please show. Oh, this is funny. I like this. It's like, bring the jury. He has a phone on his desk, a conference, like it does conference call, speakerphone. Bring the jury, send them down. They do have 21 steps up and 21 steps down to go upstairs and downstairs, which is more than a normal flight of stairs, probably because of the very high ceilings.
you'll know.
There's a screenshot right there.
But, I haven't done that yet.
Went to parochial school the whole time, Judge, so this is traumatic memories.
Yeah, he knows what I'm talking about.
Cheryl, I talked about Sister Cheryl before. With an eraser.
Oh. Yes. Yeah, absolutely.
They're just shooting the breeze, joking around.
And I remember when Sister David said that she had eyes in the back of her head, and I was only 5 years old, and I believed her.
Coyote, it's actually a birthmark. Carol, good question. ZA is in jail. He's in custody. I'm not sure if it's a no bond situation or if he just hasn't met bond, but he is brought into court each day by the deputies. So for whatever reason, he's in custody. There seems to be a lot of almost like Jensen type reminders of the glances between the client and an attorney on this.
Okay, thanks. I think I had sustained the objection, and after we conversed some more, I changed my mind. So the objection has been overruled.
So I'm going to return to the question, which was, what did Michael Campbell say to you regarding how he had happened to arrive at this scene at around 2:30 p.m.?
So Michael had said he was a close friend to Rosalio, that they communicated regularly, and he hadn't heard from him in a couple days. They worked together, they're friends. He also stated that he spoke with an Eileen Knoll, who was also a friend of Rosalio, and Rosalio was doing work at her residence at the time. Eileen said that Rosalio had not showed up to work at her residence multiple days in a row, and that she had not heard from him either. So he was coming to check.
Coming to Rosalio's apartment?
Correct.
And when you dealt with Mr. Campbell, how was his, as people either approach you or you approach people as an investigator, are there individuals who, when you ask them questions or are obtaining information from them, they appear to be reluctant to provide you either any information or full information about the questions you have? Do those people exist in your work?
They do, yes.
And are there also people you come across in your work who, when you ask a question, are actually trying to volunteer every fact they can think of? In fact, they're the exact opposite. They are trying to volunteer every piece of information from, again, your perspective as a professional dealing with individuals all the time.
Yes.
And if any of those are characteristic of Mr. Campbell, or if it's something else, what, if anything, can you say about Mr. Campbell's demeanor and attitude in that regard in your interaction with him at the scene?
So, Mr. Campbell, when he got there, he sought us out. He was looking for us to speak to, and he provided, in a concerned fashion, the information that he gave us. I didn't feel as though he was withholding information. I don't feel as though he was hiding information. He answered all our questions. He elaborated on all his answers to the most knowledge he had to give us. That explains my encounter with him.
Based on your interaction with him, did you feel that you had to hold him or in some way keep him in a place? Or
Judge, I'm sorry. I'm going to ask that the portion of the officer's testimony regarding and we can come up if you need, but a Hasseltine objection on the grounds of what the officer stated about.
It does sound like Hazeltine evidence.
Hazeltine. No.
Judge, it doesn't have to do with truth or vouching for the truth. It has to do with, again, motivating what kind of decision you can make. If one individual is in some way appears to not be providing you full information, you have one sort of course of conduct as an officer and you have to prioritize. If you have an individual where your impression, for whatever truth it is the opposite of that and you're getting all the identifying information, obviously you prioritize other investigative avenues at that time.
Arguing no.
I thought you wanted me to. I apologize.
Well, no. I'm talking about your presenting the argument that's reserved for the later part of the case, not arguing the objection. The problem is I do think it's Hazeltine evidence. It's almost a dead ringer from the social worker testifying about believing or not believing an informant. He just made a judgment.
And it's not about it's about level of cooperation. Apologize.
Let's do it this way. The officer's testimony is that having completed his discussion with Mr. Campbell, he felt satisfied that he didn't pursue anything further with him at that point. That is, you cannot accept the officer's conclusion as accurate. I'm not saying it isn't. I'm not saying it is. That's why you're here. He made a judgment based upon his what he heard.
Judge is talking to the jury right now.
And made some conclusions from it. That doesn't mean what the truth of what was stated is. Is that clear? I'm sure I could improve on that explanation, but the point is that when we talked about Hazeltine, there was a famous case where a witness who had interviewed an accuser in a case testified that, and I think it was a social worker, testified that she thought that the accuser was being accurate in what she was telling the social worker. That's not permitted, because that is the social worker is not allowed to decide the truth of it. That's for the jury. So we don't allow witnesses to speculate on the accuracy of statements made by others. On the other hand, people aren't in court all the time, and so they make their judgments based upon the world in which they live. And the detective exists in the world of investigating crimes and makes judgments. You refer to them as priorities. But none of that is conclusive on you folks. So to the extent that this testimony has been given, it can be considered only to on the issue of the
He fell asleep briefly.
quality of the police investigation. It may not be considered as supportive of the truth or accuracy of what Mr. Campbell stated. Any question about that?
Yeah. What does that mean?
Okay, thank you.
No, just kidding.
Go ahead.
That was in favor of
Were
the
you able
defense.
to obtain identifying information on
6.
how to reach Mr. Campbell again in this case?
Yes, we got name, address, phone number. He provided everything.
And was there any difficulty at all in getting him to agree to give you that information?
No.
When Mr. Campbell talked about other people that he was engaged with and talking about, et cetera, what can you say about his level of cooperation in providing collateral numbers or ways to contact those people?
Mr. Campbell provided everything that he knew regarding phone numbers, addresses, all that. He was very forthcoming.
Based on all of the things we've talked about, did you believe it was appropriate to finish your conversation with Mr. Campbell and get back to the rest of the investigation of this case at that time?
Yes, he presented no reason to hold him or to further question at that time. He was free to leave. He left.
And I want to go back to our conversation regarding Sadie Beecham. Okay, now again, that conversation was before you went into the residence, right?
Correct. It was ultimately the first thing I did was talk to her.
Went talk to her, and you mentioned that she was physically shaking and she appeared frightened for her children. Am I correctly summarizing that?
Yeah, she was very scared.
Okay, so one possible investigative avenue would have been to immediately take her down to the station and walk her through some more details. In other words, not just briefly have her tell you what she knew, but be very detailed about it at that first moment. That would have been a possible thing to do. Is that right?
Yes.
Were there concerns expressed by Sadie Beecham that caused you to feel that that should not be how you prioritized?
Yes.
If so, what were they?
Based on everything she had witnessed, everything that she had experienced, she felt as though her children were in danger, and she needed to get to them.
And why did she feel they were in danger in general? What was she saying to you in that initial interview that caused you to say, yeah, that's something I'm going to prioritize. I'm going to allow that to be the priority?
Because she knew, she was aware that Zach Anderson knew where the children were at that moment. So she needed to get to them and bring them somewhere where he wouldn't know where they are.
And when you say Zach Anderson, is that a person you now know in this investigation?
Yes, the defendant.
So for the purposes of our record today, when you have referred to a person named Zach Anderson, can you point out who that person is, say what they're wearing today?
He's sitting in a defendant chair in the middle with a gray suit, tan and blue tie.
Now, as Sadie Beecham was expressing her worries about the safety of her children with Zachariah Anderson, the defendant, knowing their location, was she still manifesting those physical shakings and scared things you've talked about so far?
Yes.
Based on what she told you, the content of what she said, and what you observed about her physically, did you make a decision about whether she would be allowed to take care of that priority before you interviewed her further?
Yeah, she provided where the children were, where she was taking them, and that she would be coming back as soon as that was completed.
And was there anything about her demeanor that caused you concern about her level of cooperation, such that you might feel you had to take other steps, to preserve an ability to be in touch with her?
No, she was genuinely scared.
I think this witness is super nervous.
Consequently, were you able to again interact with
cross.
Sadie Beecham later that afternoon?
Yes.
And had, to your knowledge, had she been given the time to accomplish the priorities she had?
Yeah, I believe she was. She left that scene after talking with her roughly 1 o'clock, 1:30ish, and she. I met her again at about 3:45.
Okay, now I want to now bring you back to, so everything we've talked about so far has occurred in the afternoon hours, starting at 11 a.m., but now the afternoon hours of May 19th. Is that correct?
Correct.
At some point, did you have occasion to know that the defendant had been placed in custody?
Yes.
And if you know, what jurisdiction or was it Kenosha police officers who placed him in custody, if you know?
No, it was Mequon Police Department.
And did he eventually have occasion to be in your presence?
Yes.
Where were you present with him? Were you in Mequon or in Kenosha?
He was arrested in Mequon, brought to Kenosha.
So your interaction with him was in Kenosha?
Yes.
And if I indicated that appears to have begun any interview of him occurred to have begun at 10:48 p.m. on the 19th, 10:49 p.m. on the 19th of May 2020, do you believe that to be accurate?
Yes.
And am I correct that the interview ended at approximately 12:18 a.m. on what would then be the 20th of May?
That's accurate, yes.
So if I'm doing the calculation, that is 1 hour and 29 minutes. Does that sound right?
Yes.
Okay. And did you Mirandize him? In other words, read him his rights during that interaction?
Yes, he was read his Miranda rights.
And during that interaction, how many people were involved in any questioning of
random
the
crime
defendant?
scene photo?
It was myself, Detective Correa, and Mr. Anderson.
And was he in an open area, or was he in an interview room? What sort of environment was he in?
So we were in an interview room. Detective Correa on one side of the table, Mr. Anderson on the other side of the table, and I was sitting in between.
And at the point that you came in contact with him, had you received guidance as to what the defendant was aware of about any circumstances regarding Rosalio Gutierrez? In other words, had you been made aware that he had some knowledge of some subject matter as you began to speak to him?
Yes, it was my understanding Mequon PD had informed him why they took him into custody, and he knew why he was coming to talk with us.
And so do you believe he had an awareness based on the information you were provided that an individual named Rosalio Gutierrez had disappeared?
Yes.
So you believe he knew that at 10:49 p.m. on the 19th of May?
I'm going to object as far as speculation as to what he believed Mr. Anderson knew.
Well, Judge, again,
and if it's not speculation, then there's been a lack of foundation.
Again, it goes to what the officer did at what point in time.
If I may respond to that, Judge?
Go ahead.
Thank you. This isn't getting to why the officer did something, or this is getting into statements of Mr. Anderson and what Mr. Anderson believed to be or not to be. I think we need to make a clear distinction between the other witnesses.
Well,
Ooh, breaking out the black binder.
this is it's similar to the other witnesses.
This is normal
but
speed.
This is a huge amount of speculation, and it's explanatory only on the issue of why the police acted as they did, which in and of itself is only is usually not an issue that we examine in any depth. There is, however, a claim in this case, which has been made by the defense, that the police did a inadequate investigation. And so to some extent we're scrutinizing, well, you're scrutinizing the adequacy of the investigation in terms of the ultimate issue for you, which is the pursuit of the truth of this incident. His conclusion from what he heard from the defendant is totally insufficient to establish what the defendant was thinking, and is explanatory only of why he acted as he did in furtherance of the investigation. So I'm going to let the question be answered, but you must understand that under no circumstances are his conclusions legally adequate to
well, he finishes, this is a win for the state.
Base of
Prosecutors
verdict as to the truth of anything in our strictly for explanation of course of the police investigation.
Sentences
Is that clear?
should not take more than 2 minutes.
Okay, thank you. Go ahead.
And because of the hour, I'm going to move on to another topic, and at some other time I'm going to come back to the interview, just because I don't want to chop that up.
Do what you wish.
So I'm just explaining to the court why I'm changing topics after the court rule.
Trying to match the text on that reserved sticky note behind it, on the pew there.
Did the Kenosha Police Department do some searching at a residence that they believed was owned and occupied by the defendant on May 19th, 2020?
Yes.
And was that address 6813 West Highland Road in the Mequon area?
Yes.
And on the 19th of May, were you in any way involved in that search?
No, I didn't partake in any searches there that day.
And was that partly because you instead were involved in interviewing the defendant?
Correct.
Okay. On the 20th of May, were you part of a return to that address at 6813 West Highland Road to check out additional areas and to do additional search for evidence?
Yes.
And was that during the daylight hours?
Yes.
And you hoped that being there during the daylight hours, I assume, would assist you in searching the property. Is that correct?
Correct.
Okay. Do you recall in general, can you in general describe that property? In other words, how do you get there? How do you get in there? And what in general do we have that you needed to look at?
Yeah, so it was a gravel driveway entering the property. There was a house and several outbuildings, including a couple garages, a couple old chicken coop areas, a couple lean-to parking areas, some sheds, and I remember there being a camper parked on the property as well.
Richard, thanks for your support.
And when you got there on
Good
the
to see
20th,
that green courthouse by your name.
Did you observe vehicles that were of some interest to you at that time?
Yes, there was a black Audi sedan and a black Chrysler minivan.
And had those vehicles in some fashion come up in your interview with the defendant on the 19th?
Yes.
I'm going to show you now what's been marked as State's Exhibit 1, Photo 254. Just ask you briefly if you recognize that item from your search of that Mequon area residence on May 20th?
Yes, that's the black Chrysler minivan that I saw at the residence.
And did that vehicle appear to be owned by the defendant, if you know?
I don't recall.
Okay.
Is that a Winnebago in the background?
At some point, first of all, did you actually search that vehicle, or did you just observe the interior of that vehicle?
So I
the ladder up on the roof too.
Looked in the side and rear windows of the van. I never went inside.
And what could you, in general, observe from the inside of that van?
Michelle. Yes, you have. Looks great.
Observed a container of Clorox bleach wipes, an opened box of garbage bags in the back.
Bleach wipes or bleach?
I observed that the rear seats were out of the minivan. I also observed that there was a large piece of carpeting removed from the back. About a third of the carpeting in the back area had been roughly cut out, and the carpet that remained had several white blotches on it that appeared to be like a bleach stain.
I'm going to show you now.
Soon, 6-volt bus will be there soon. Thank you so much for all your support.
I'm going to show you now what's been marked as Exhibit 1, Photo 263. Is that a vantage point or a view that you
oh man,
that you believe you observed in the context of May 20th, 2020?
So that's with the tailgate up, the lift gate up on the back. But yeah, I was peering through the window of the van, and that's what I observed.
This is the vantage point. Essentially, this
Looks
is
like
from the
used
back,
hefty
but this is what you
garbage
saw
bags,
when you looked
Brand
inside.
name. It didn't
Yes.
go cheap.
So if you could take, if the court would indulge us and let you have that pointer again, then I'd ask you to approach and first point out to me where the items that appear to you to be bleach stained.
I don't need to talk.
Use the drumstick.
Where's the area that you felt appeared to be bleach stains?
This whole area here. There's some here. The white off-colored.
Okay. And then the area that you said was about, I think you said about a third that was rough cut. Is that area depicted in this? And if so, can you just point that out in general?
Yeah, this is a bad look. This is more than a little bit of circumstantial evidence. Could have held a body, possibly. No, that's not weird. I actually had a friend who works at a funeral home. My age, growing up, he and his wife, they actually lived in the funeral home.
You're inquiring about the area that was cut out, correct?
They'd work at night.
If you could just point that out for the jury.
And when the call would come in, they'd go pick up
this whole third back
customers.
section.
And does that area include exposed wires?
It does.
Okay. And exposed sort of bottom of the vehicle because the carpet's out?
Correct. This didn't appear like a factory, like how it comes, because the under insulation area here was kind of sticking out, and a factory cut would be nice and clean. This was not clean cut.
Now, did you do anything further with the van, having made these observations yourself?
That day?
Yes.
No.
Okay. Was the van retained as evidence so that other decisions could be made about the van based on the observations at a later date?
Yes, it was secured and decided that we would take the van.
You'll hear that they did find
from that
his
Highland
DNA in that
Road
van.
address?
One
Correct.
speck of
And
blood.
where did it go to, if you know? Only if you know.
The Wisconsin State Crime Lab.
Okay. And what is the Wisconsin State Crime Lab a place that analyzes things like this van, if you know?
Yes.
You can sit back in your chair. And so would that be the logical place you would send it for a more thorough investigation than the Kenosha Police Department is able to do?
Yes. State Crime Lab's probably would do the most thorough job of processing evidence.
I'm going to now ask that you take a look at Exhibit 1, Picture 271. Is that a vehicle or a vantage point you recognize from the residence?
Please say it right.
Yes, that was the Audi sedan that was parked in the driveway.
Had this also come up in the interview?
Yes.
All right, and so that was also at his residence on the 20th when you arrived?
Yes.
Did you have an opportunity to search the house itself?
Yes, I went through it.
Do you recall how much land we're talking about here?
I believe it's 4 acres.
And did you have an opportunity to search the outbuildings that you described?
Some of them, yes. Some of them.
Did you have a crew of people with you that day?
Yes.
Do you believe that, and was it Kenosha Police Department?
Yes.
Do you believe that all the buildings were searched on the 19th and the 20th?
Yes.
And were the grounds searched as well?
Yes.
Was there anything of note or interest to you, knowing that you've talked about the weather conditions over the last few days before and the heavy rain? Was there anything of note in the outdoor area that was of any interest to you, particularly knowing that it had been raining?
Yes, there was a larger sized fire pit that was smoldering directly behind the residence in a grassy area.
And can we see that general area in this picture or not really?
Just here, I can point.
Yeah, if it's partially depicted. Okay. All right, you can go back.
Partially depicted. It must be back there behind the trees.
And you said that was still smoldering?
Yes.
And what does that mean to you? How were you able to tell it was smoldering?
It appeared the ash in the fire was still burning and creating a smoke from it.
And was it? It looks fairly sunny at the moment you're there on the 20th. Is that at least based on that picture? Were there moments of sunshine on the 20th that you know of? It's not the 19th. It's the day after, the 20th.
Yes.
Okay. At some point, did you also find that there was a dumpster at the residence?
It's literally as big
as
the car.
Yes, it's in that picture right there.
Okay. Is it a blue object in the picture?
Yes.
Were the contents of that emptied and looked through?
Yes, we actually had a dump truck or a loader come and dump the contents out in the driveway.
And was there garbage either in the house or attached to the house in some fashion? Connected with the house? Garbage bags, garbage cans?
In the dumpster?
Okay. What about in the home?
Yes.
Okay. Was that garbage searched?
Yes.
And was there a trailer located at this home?
Yes, camper.
And did it have debris?
Yes, there was a trailer. There was also a camper trailer.
Okay. So, I'm sorry. Okay, so there was a trailer like that somebody would use as a residence or a place they might park at a campground or something?
Yes.
Okay. Was that searched?
Yes.
Okay. Was there also a trailer that someone pulls to move items around?
Yes, it had. It was a sided trailer with some furniture and like lath and other construction stuff, I guess. Yeah.
Where was that located at the residence in general?
Next to the dumpster.
Okay. And in that, were the contents of that trailer that we've just talked about also looked at in this case?
Yes, it was thoroughly searched.
Okay. I'm going to show you what's been marked as State's Exhibit 1, Picture 274. Is that the trailer we've talked about?
Yes.
Before it was looked at item by item?
Yes.
Now I'm going to show you what's been marked as Exhibit 1, page 275. Is that the same trailer?
Yes.
Is that a vantage point of the trailer that is a way shot of some tools that were located in that trailer?
Yes.
And again, is this before the vehicle itself or the trailer itself was looked at item by item?
Yes.
And then I'm going to show you what's been marked as photo number 276 in Exhibit 1. Is that a close-up of tools located on the defendant's property at Highland Road in that trailer?
2 hammers and a knife.
2 hammers and a knife, and the knife is in a sheath of some kind?
Correct.
And are these all true and accurate pictures? In other words, that's what you remember from the date of?
Yes.
So at some point, did you come to believe that persons who you could identify who had last seen the defendant described him as wearing a flannel shirt?
I'm going to object as far as hearsay.
Hey, another one.
That is being used for the truth of the matter asserted.
It only goes to, again, these are people who are going to testify. It goes to why he would search for this particular item. You know, he's doing a search. It only explains why this item would be an item he is searching for.
Okay,
you recall a flannel shirt being brought up by witnesses saying when they when they last saw the defendant, he was wearing a flannel shirt of a certain type.
Yes.
And were you provided a picture of that flannel shirt?
Yes, I was.
So you knew precisely what sort of shirt and what you were looking for when you did this search warrant on the 19th and the 20th, weren't you?
Yes.
You weren't there the 19th, but on the 20th you were.
On the day of the 20th, I was, one of the key things I was looking for was that flannel shirt.
Okay. So I'm going to show you what's been marked as State's Exhibit 42.
Sorry.
I don't know if she's a public defender or not. If
is that a picture
it's
provided you by witnesses so you knew what shirt to look for?
Yes, what you see is significantly blurrier than the photo that I have. It was a lot clearer, the one I looked at.
But it does depict the same shirt.
Yes.
That's a bathroom photo.
And so you looked for
mirror.
that shirt?
I did.
At Highland Road?
Yes.
Did you, was that shirt found in any of the buildings that we've talked about?
I was unable to locate that shirt.
Was it found in any of the garbages that you looked at?
No.
Was it found in any location on that property in any way, shape, or form?
No.
Having seen that a third of the van carpeting of a van on the property appeared to have been not industrially cut out, did that become something you were interested in?
Absolutely.
And so as you searched all of the areas we've talked about, did you look for this van carpeting so that you'd be able to account for it and see if it had any evidentiary value?
Yes.
And did you find that in any part of this property or location?
No.
Were you, had you spoken to witnesses who indicated that they had seen brand new duct tape and brand new rope at the residence just on the day that Rosalio Gutierrez disappeared? Were you told that on that same day, earlier in the day, duct tape and rope had been present at the residence?
Yes.
That was new?
What's that?
That the person believed was new?
Correct. Brand new in packaging.
And did you attempt to search for those items
I did.
at the residence?
I did.
Were those items anywhere located at the residence?
No.
Judge, based on me finishing that topic and the next topic being a fairly significant one, I would suggest this is the ideal time to break for lunch.
No problem with that, Judge.
Any problem with that? Let's take a break, and let me ask that you return at 1:15. Is that convenient? Okay, please don't read, watch, or listen to any account of the trial. And Any questions? Thank you.
Okay, so we're going to skip their lunch and keep going. It is 3 o'clock here. I'm going to turn it back up on fast speed again, at least until we get to the cross-examination of this witness. Okay, so lunch is almost over. We're a couple days behind, but we're catching up fast because we're skipping breaks. We're covering 3 days today. Okay. Just getting caught up to right the moment the judge comes back.
I'm almost done.
Sorry.
That interview that occurred in the next section.
Wait for it. There we go. Okay. All right. We're going to speed this up too. Yes. All the breaks are very fast. There's the throne. You can see the throne there in the background. It's the judge is sitting down. It's got the state seal.
Ask
full
about
color there.
in this next section, which is the defendant being interviewed by officers. I'd like the defense to have an opportunity to weigh in, and to the extent the court is comfortable, to give me guidance on how to approach this, if at all. Can I do that briefly?
Yeah.
Okay. So I intend to ask about the contents of the hour and 29 minute video. Interview that occurred between the defendant and the two detectives. I would like to be able to ask the detective whether there were additional questions that the detective did not have the opportunity to ask during that interview.
And
Let me finish. I'm almost done.
Sorry.
And then also, were there any other opportunities to interview the defendant? So I don't intend to go any further than that. But again, we're talking about this avenue of what was the investigation. Certainly an hour and 29 minute video or interview does not, as the court is well aware from its long experience, is not an amount of time to cover all topics that would be necessary. I don't intend to go any further with it, but I believe that is the line, and I'm asking the court if I have permission to go that far and no further.
Go ahead.
Thank you, Judge. Asking why there were other questions that should have been asked that weren't, and then that they weren't able to have the opportunity to question him again is encroaching on the fact that my client asked for a lawyer, and that was why the interrogation concluded. So asking those questions, implying that there's more and that my client chose not to speak, is directly going towards his right to remain silent at that point. So I would argue that the state cannot ask those questions of, oh, would you have asked more questions if you would be able to? Because the inference there is that they weren't able to because he invoked his rights, and that they didn't get to talk to him again because he invoked his right to silence.
And again, I only bring this up because of the issue of the adequacy of the investigation, right? So there are natural limitations. I'm aware I cannot go any further. So counsel indicated, what I can't argue, and I absolutely agree. I can't say here's why or in any way imply that in argument or in question. But I do think it's a proper question, right at the line. It's a proper question to ask as I described to the court.
Well, the problem is you're lobbing the ball over into their court and saying, did you have an opportunity to ask more questions?
As you often are when you go to the line. Right? I mean, that's the nature
but we don't want to do anything brazen.
Right.
You're lobbing the ball onto their side and making them respond. And they're kind of handcuffed. If the answer is, he lawyered up. And of course, then you're in the forbidden woods.
Right. So really the analysis, though, is am I asking a question that comments on his silence or comments on his invocation, right? So the court is right. It has some consequences, but the question is the question one where I am calling on the officer to indicate in some fashion that he has invoked his right to silence or to an attorney? I would suggest to you, as suggested, the question does not do that. Of course, I can't argue. I apologize.
So a very, very tight interpretation. You could make that claim, but the problem, as I say, is you're forcing the defense into a position where it has to come up with an answer, and if the answer is that he had talked to a lawyer, and whether he talked to a lawyer or not, he simply decided not to discuss anything further with the police, they can't respond, and so it's sitting out there, and if during the remainder of the testimony a juror is after hearing the remainder of the testimony, a juror is thinking, all these years since this, and the defendants never told the police anything more, then you're definitely, what is the name of the case? I think it's Champlain Chambers, one of those. Not one of those, well, whatever it is, the rule is very clear that there's no comment permitted by the prosecution on the failure of the defendant to address the case.
That's a bright line rule, and I'm aware of that.
Okay.
Now, what has happened is the defense has lobbed into the states. Let's be sure we talk about this fully in the venting of what you described. There's been an opening statement. It is certainly said detectives made a number of poor choices here, right? I mean, that is the clear thing, right? So a reasonable juror hearing the 25, perhaps 30 questions that officers did ask would very reasonably, based on the argument made and the ball being lobbed into our court, say, well, why the heck didn't the officers ever address with the defendant why this van is cut out, a third cut out, or any other thing that the state suggests is of significance here? Why wasn't that ever brought up to the defendant? That sounds like it's the same pattern of they didn't test fingerprints at X, Y, and Z. They didn't search this part of the woods. And we're left with no way to respond because, in fact, those questions would have been asked or certainly could have been asked had there been a different posture. Now, again, I am absolutely conscious. I am not allowed to bring up an invocation of either silence or the right to an attorney. But I think that the simple declaration by the detectives that they would have asked that they would have liked to ask additional questions and that they never had an opportunity settles the matter. It creates a situation where the prosecution is not going to be penalized based on the argument made by the defense for any question that the juror wishes a detective would have asked the defendant. I mean, otherwise, I'm left without an explanation.
I'm not sure when the judge rules who to give the credit to because there was no objection here.
If the court says I can't even reach that line, I have no way to respond to a juror concerned that in the context of what's been said, what the heck, why wouldn't a detective ask that question? He asked 25 others.
First, about the ball being put back in their court. The ball's in their court. They have the burden. It's never that we've shifted that burden here. And second, as far as the answer to a question of why weren't you able to answer these questions that you would have, the only answer that a detective or any witness can give is that we weren't able to continue questioning because he invoked his Miranda rights. So there's no leeway here. It's not the defense's fault if the state doesn't have any other evidence to support its claims. It's their job. The case that deals with this issue is Griffin versus California. It's 380 U.S. 609. And in that case, and I'm just going to read, says that a comment to the jury by a prosecutor in a state criminal trial upon a defendant's failure to testify as to the matters which he can reasonably be expected to deny or explain because of facts within his knowledge or by the court that the defendant's silence under those circumstances evidences guilt violates the self-incrimination clause of the Fifth Amendment of the federal Constitution as made applicable to the states by the 14th.
This should have been cited in the Murdaugh trial.
And also this concept that I'm going to ask an officer, well, why didn't you ask my client that? Well, obviously, I'm not going to violate my own client's constitutional rights. I would not ask a question of that sort. The questions that the state have outlined are clearly across the line of what's permissible under a constitutional lens and pursuant to Griffin versus California and my client's Fifth Amendment rights.
The case does not stand for the proposition that I can't reach this place that I am. I've been very careful in the litigation here. I've approached the court first. I'm doing the exact opposite of commenting on the defendant's silence. I'm asking the court for guidance on how I can structure a question to a detective that allows there to be no comment on silence, but also allows a fair presentation of this evidence to a jury in the way I've described.
There's no objection.
The only other option we're left with is a jury wishing there were answers to other questions, knowing a series of questions have been asked, and left with the implication that officers are not confident enough or not or too lazy to ask these additional questions. Now, again, I don't mean to
the
comment on either
prosecution
of the two things.
is asking for
Simply ask
guidance.
these very structured questions.
There's
I
no
believe I'm doing it
objection
in
here
the
to
appropriate
be
way. It's the
handled.
exact
The
opposite
court's
of
giving him
case cited
guidance on
where
how to
a
proceed.
prosecutor actually comments on this. I am trying to be careful in my litigation here and ask the court for guidance to be able to ask those two questions. Did you ever get a chance after the interview and so forth? Did you ever question the defendant again? And then the second one is, were there other questions that you would have desired to ask based on your investigation? Period.
Yeah, and of course you did the right thing by bringing it up first.
Sure.
But I
If he doesn't let him go there, I'm going to cite this one for
to
the defense.
To the extent that you ask me for guidance as to what you can do, that I can't do. I can't give you advice as to how to
Well, I've told you
present your case, and I've made it pretty clear what you can't do.
But I told you the two specific questions I intend to ask, so I think the court can probably help me with that.
Well, but definitely the second one is totally out. What was the first one?
The second one is, did you have any other opportunities to speak to the defendant?
No, that's
okay. So the first one was, are there other questions that you desired to ask of the defendant that you did not ask?
Yeah. You know, the fact that you're complaining that you're left without a way to somehow effectively cover this, that sometimes that happens, and sometimes it happens because of the Constitution. But it's what it is. You know, and I don't know if you know, can you cover something like that in your argument to the jury and say,
I imagine that is more problematic.
I didn't tell you what I was going to do to raise your hair or the defense. And I think I'm actually going to stop and not do it. But there's at least one way I can think of that I would at least be tempted to do. And I'll leave it at that. I don't think you're without a way to buttress the police investigation, but the way that you're explaining to me is not one that I think is one that I would sanction or even permit.
Okay.
No.
Okay, thank you.
Okay.
I'm going to say that's going to be for the defense. The defense would have objected as soon as he started. So even though there was no objection, the prosecution brought it up. The ruling went against the prosecution in that one. He can't go to where he wanted to go. So that brings us, I think, 9-8 on the score. Thank you, DMB, for that.
Were there late jurors or? No. Everybody was here on time, but it just took a long time to get. Hello. Would you come down, please? Yep.
That's the judge calling the jury down. So, no.
Anthony Ward, what's going on? You have a divorce trial when? When?
Next Tuesday would be tomorrow.
Well, another state is 9 miles away.
Bring the jury.
All right. Yes, she's arguing that it could violate his Fifth Amendment rights. The prosecutor is not allowed to comment on the fact that he didn't comment anymore, or he chose not to speak to police.
Enjoy the day.
Because it could infer guilt. No, that was not to us. The judge.
No, I haven't checked the weather forecast. Are they still talking all kinds of ominous weather this afternoon, or is it? Oh, it's tomorrow. Yeah. Okay.
I'll see you, Bella. Sorry, this one's a tough one. I think the
there was a chance it was all going to be rain here.
They started approaching, and then they said it's worse south of us, but with the slightest change in wind. Meteorologists are my favorite.
Well, you're being too harsh. They've correctly predicted 45 of the last 3 snowstorms.
Judge, currently the Weather Channel is saying snowfall around 1 inch, for whatever that's worth.
Hey, this is Wisconsin. I won't even notice. All right, Mr. Gravely.
Thank you, Your Honor. Detective, when last we were here, I was about to again begin to ask you about the interview that occurred on May 19th, 2020, regarding the Zachariah Anderson. And again, you've identified Zachariah Anderson as the individual here in this courtroom. Is that correct?
Correct.
And you spoke to him for about an hour and 29 minutes in total?
Yes.
And that was a question and answer format?
Yes.
And did it include the defendant also asking some questions during some of that period?
Yes, he had some.
And did you provide him any nourishment, any food or water?
We gave him water, which he requested a couple of times.
And ultimately, that interview then concluded, if I got this correct, at 12:18 a.m. Does that sound right?
Yes.
Okay. So in the time period of that interview, did you provide any threats or promises to the defendant to get him to provide any information?
No.
Did he provide that information? Did he answer some of the questions you asked at least?
Yes.
All right. Did you at some point have occasion to talk about a phone that purportedly appeared to have ended up in a car driven by his ex-girlfriend, Sadie Beecham?
Yes, I did.
And was this something that you asked him about?
Yes.
And what do you recall him telling you about whether he had intentionally placed that phone or some other explanation?
So Zach had said, Mr. Anderson said that Ms. Beecham
on a first
had
name
dropped
basis.
the kids
Zach.
off at his residence. And during the course of taking his son out of the back seat, he believed that this cell phone may have fallen out of his pocket, or his son may have grabbed the phone and put it in the car.
What, if anything, did he say about whether he, on purpose, hid that phone under the car seat?
No, he said he didn't realize this until after Sadie had left and he realized the phone was gone.
What, if anything, did the defendant say about how he managed to figure out where that phone was then located after it was in Sadie Beecham's car in that location?
Mr. Anderson said he contacted the phone provider, Cricket, and Cricket told him that the phone pinged in North Kenosha.
What, if anything, did the defendant tell you about having loaded an app on his electronics that would, in fact, trace the exact location of that phone prior to losing the phone? What, if anything, did he tell you about that?
He said nothing about it.
What, if anything, did he offer to you regarding indicating that on the date that Sadie discovered that phone, that he actually had accessed that app to be able to discover where the phone was using the app in his own electronics? Did he mention any of that to you?
He said nothing to that.
Did you ask what, if anything, did you ask the defendant about having been to Sadie's home during the early morning hours over the last few weeks? Did you ask him that question?
Yes, I asked him if he had been to Ms. Beecham's house at any point during the early morning hours.
Let me just stop you for a second. And did they live together at that time?
No.
And per your investigation, was he welcome at that house in the early morning hours?
No.
Okay. So when you asked him that question, it was a specific question about in that context. Is that true?
True.
And what did he first offer up to you as his explanation for a visit to her home in the early morning hours? What was his first explanation?
He said there was a time when he had picked up a couch late one night and he was dropping the couch off there late.
Go ahead. And did you then repeat the question, ask him again, and ask if he had his kids along on any occasion? Did you ask him that?
Yes, I asked him if there was another time when he had his children that he went there.
And then did he offer that he had?
Yes.
Could he remember the date, as best you remember?
No.
And which children did he claim he had taken along with him?
All three of his children.
Okay. So he has a couple of twins who are younger and then a daughter who's 10, 11, 12, something like that?
Correct. He said he had taken his daughter as well as the two twin boys.
Was it at night?
Yes.
Did he indicate why he felt a need to take his children? He had the children with him, is that what you're saying?
Yes.
So why did he indicate he felt he had a need to take his children when Sadie Beecham would have not been caring for the children?
So he, first he said there was a car in the driveway, and then he stated he had a premonition that there was someone at her house.
And at that point, were these two in a marriage, as far as you know?
No.
Were they in a situation where any of the children would be at Sadie's home?
No.
Okay. So he and the children drive to her home, per his report? Is that right?
Correct.
And at what does he indicate happens when he is at that residence?
So he said when he pulls in the driveway, there's a vehicle there with Colorado license plates.
And let me stop you. Does Rosalio Gutierrez have Colorado license plates on his vehicle that you saw at his residence when you discovered he was gone?
Yes, he's a white Ford Explorer with Colorado license plates.
Okay, so what else did he say?
He said he got out of the vehicle and looked through a window.
Looked through a window through a window at the vehicle?
Looked through a window at the house.
Okay. And whose home is he speaking of?
Sadie Beecham.
Did he say he saw some things inside?
Yes, he said he saw them on the couch.
Okay. And did he indicate whether any of the children were also involved in looking in the windows?
Yes, he said.
I'm not sure why they're objecting to these questions. They're very leading.
Also came out of the car and looked through the window.
And did he indicate that he had that was something he was a part of in some fashion?
He had told me his daughter did this because she wanted to.
And did you at some point ask the defendant whether he recorded any using any devices of his at Sadie's residence when he and his daughter were there looking in windows?
Yes, he denied recording anything, although he did admit to having a cell phone in his possession at the time, but that he used the lights on because it was dark.
And was it his regular cell phone?
I'm going to object as far as foundation.
Did he? I'll ask again. I'll clarify. Yeah. Did the defendant explain to you that he had more than one phone that he was using on a fairly regular basis?
No ruling on that.
Yes.
Okay. And did he describe one as his primary phone and another as his secondary phone?
I guess, Judge, I've been lenient, but all these questions have been extremely leading.
Extremely.
So I'm going to object to leading and ask, and then it not be leading.
I apologize. I was just doing it in this situation. I was just doing it because it was a foundational question. So, but
it's just been like 5 minutes of foundational questions then.
Tending towards being suggestive. So, if you can rephrase.
Okay, so that's sides
what do you recall
with the
about
defense
whatever
on
he
that
told
one.
you about these phones?
He had two phones, one he used primarily for calling.
And what, if anything, did he say about doing any recording using any devices on this particular date?
He did nothing. No recordings.
At some point, did you begin to ask questions regarding a new boyfriend of Sadie's?
I did.
And what, if anything, was the defendant's discussion with you when you first brought up this individual in terms of things like whether he knew his name, a general discussion of what he appeared to know about this new boyfriend?
He said he found out about the new boyfriend through his daughter, as well as a grandmother. Grandmother had shown daughter a Facebook profile of this subject, and that's how he found out who he was. I asked him what his name was, and Mr. Anderson said I believed it was Junior, and that his last name started with a G, and that he was a Mexican.
And what, if anything, did the defendant ever tell you about the fact that in his own phone he had well, let me stop. Okay, so did the defendant ever reveal to you that he actually did know the full name of the individual that Sadie was dating? Did he ever tell you, yeah, I know the guy's name?
No.
Now, at some point, did you begin to focus on the vehicle that the defendant may have driven at various times that you were interested in?
Yes.
And what vehicle specifically were you interested in regards to your interview with him?
I asked him about the Chrysler minivan that was parked in his driveway.
Not the girlfriend.
And what do you recall about the defendant's response when you first suggested anything to the effect that he was a driver of the van?
He described the minivan as either being black or blue or something, and that was his words. He also indicated that he doesn't drive it much, and that it's basically there for the taking.
Did he describe to you that he drove a different vehicle, if you know?
Yeah, the Audi. He mentioned the Audi.
Okay. And
no, you said Audi the first time, and now it's Audi again?
What, if anything, did he say about whether he had ever been in Kenosha at a time that Sadie had been there?
He said he couldn't remember the last time he was in Kenosha.
Period?
Period.
Okay.
He did mention that he plays board games with his brother, and they may have been in Kenosha, but he didn't recall ever being in the city of Kenosha.
And in connection with being there because Sadie was there, what, if anything, did he tell you about that?
I'm sorry, repeat that?
Yeah, did he indicate that he ever followed Sadie down here to
Sadie
Kenosha?
right there.
No.
At some point, did you direct your questioning to whether anything had ever been taken from Rosalio Gutierrez's vehicle, that truck?
Yes.
And what, if anything, did the defendant tell you about whether he had taken any items from the vehicle of Rosalio Gutierrez?
He told me to spare the accusations. He's already been accused of this and that it didn't happen.
And what, if anything, did the defendant offer to you that in one of his phones there is a screenshot of, in fact, a document, a registration document regarding that truck?
Nothing.
What, if anything, did the defendant say to you regarding whether he had any jealousy towards the fact that Sadie had a new relationship?
These are quite leading.
He had admitted to me that he did have some jealousy, however, spun that and said that Sadie was the one that was jealous of him.
And
whatever makes you sleep at night, I guess.
What, if anything, did you ask whether these two individuals, meaning the defendant and Rosalio, whether he had ever seen Rosalio?
I did. I asked him how many times he had seen the subject he was referring to, and he had told me it was just the one time when he peered into that window.
So, what, if anything, did the defendant offer you about about his phone being in Kenosha on May 13th, which would be a different time than the time that you are speaking of? What, if anything, did he offer about that?
Nothing.
What, if anything, did he offer to you regarding the idea that he was texting Sadie, directly quoting things that Rosalio was telling Sadie in Rosalio's residence on May 13th in Kenosha?
He said nothing.
Got to object here.
So as to May 13th in Kenosha, what, if anything, did the defendant say at all about that in the context of perhaps being a second time he had seen Mr. Gutierrez?
It was never mentioned.
At some point, did you bring up an individual named Steve Lentz, or did the defendant bring up a person named Stephen Lentz to you?
Yes.
And just so we understand, who is Stephen Lentz in this investigation, if you can tell us?
Stephen Lentz was identified as a friend of Mr. Anderson, a neighbor. At one point, Mr. Lentz actually lived in his backyard in a tent at one point. Mr. Lentz's mother lives right down the street from Ms. Beecham, about 400 feet down the road on the opposite side of the street.
From where Mr. Lentz, and was Mr. Lentz residing there in April and May of 2020?
Yes, he was.
And from Mr. Lentz's then residence, could you see any portion of the house or a place where Sadie Beecham was living?
Yes, you could see the driveway of Ms. Beecham's residence.
And were you able at some point to obtain a phone number from Stephen Lentz?
I did.
And just for purposes of us clarifying, was that phone number, based on the records that you reviewed, et cetera, 414-378-4935?
Yes, I believe so.
Okay. So let's go back to the interview with the defendant. At some point, Stephen Lentz came up. What do you recall about how he came up?
We went back to the idea that he had a premonition someone was at the house. Ultimately, Mr. Anderson told me that there was a guy named Stephen Lentz that would call him and tell him when vehicles are in the driveway. But he also stated that he had never told Mr. Lentz to provide this information.
And what, if anything, did the defendant ever tell you about communicating with Stephen Lentz, asking him on occasion if there were cars in Sadie's driveway?
Nothing.
Now, when you spoke to the defendant, what were you telling him that you were questioning him regarding?
I told him we were investigating the stalking incident.
Did you tell him who the people were who you were suggesting he might have been stalking?
Yes.
Okay.
And it's paused. Hang on.
He had been arrested. Did you were you having this discussion with him? So, if I understand correctly, there was a contact with law enforcement.
This will probably be a 3-week trial. We're trying to.
And then about how long
get
after
us
that
up
arrest
towards
in
Sarah
Methlon
Boone
do you
with
estimate
it.
it was before you're having a conversation with him about stalking Sadie and this other individual?
I don't know the exact amount of time, but probably 3 or 4 hours later.
Okay. And at some point, did you focus on attempting to figure out where the defendant had been on the day of May 17th, 2020?
Yes.
Okay. And if you can briefly say, why was that your focus, as opposed to the 16th of May or the 23rd? You know, what was the reason why you were focused on the 17th of May in your questioning of the defendant at that moment?
From what we knew at the time, that was the last communication with Rosalio, was on the 17th, and we believed that that was the day that the incident occurred, from what we knew at that point.
And did you believe that also to be in the evening hours?
Yes.
Okay. So you had a general amount of time that you were focused on because that's where your investigation was at that moment?
Correct.
So do you remember focusing on that with the defendant, where you asked him, you know, so please tell me about what was happening on the 17th of May?
Yes.
Okay. And again, you're on the 19th of May now?
2 days later, yes.
So you're asking him on a Tuesday what happened on that Sunday during the day, is that correct?
Yes, day and night.
Okay.
Yep.
And so what do you recall about what he offered to you first in terms of his activities on Sunday?
So he said he was with the children during the day, and Sadie came to pick them up.
Did he tell you in general when that occurred? In general?
I don't recall.
Okay.
I wanted him to keep going with the rest of the remainder of the evening, and he said he thinks he went to a girlfriend's house named Christine.
Okay. Did he eventually offer the last name of that girlfriend as well?
Yeah, Christine Remsburg.
Okay. And did he indicate that when he went there that he believed he had spent the night? Was that his initial discussion with you?
He never. He was very wishy-washy on what he did that night. He said he may have been there, he may have stayed the night. Wasn't really sure. Yeah.
And did that wishy-washiness come when you pressed him and said, you know, dude, you don't remember what happened 2 days ago? Is that when that happened?
Yeah, I was unable to get anything like concrete as far as what he did that night, and he was just throwing out things. First he said he stayed with her, then he said he may have called her, he doesn't remember. He just never gave me an answer.
What, if anything, did the defendant say about ever having an in-person interaction with this person, Rosalio Gutierrez? Did he offer any, what, if anything, did he offer in regards to that?
Nothing. He said he only saw him that one time, which was through the window.
What, if anything, do you recall about the defendant offering up something about Sadie and her having a nice jacket and what that meant? Do you remember what that was about, if anything?
He said Sadie dropped the kids off at one night, and
yes, Lindsay, that's the
one. Called him Zachariah, and said that she had a nice jacket in the back of the car, and suspected that she was going down to Kenosha to visit Junior because she had a nice jacket in her possession.
I'm not sure why they have a mic right in front of the defendant. I'm hoping they'll get to cross here today before this ends. We'll see how the judge handles breaks like this. Newman would have called for everyone to stand up and do some yoga by now. Wait.
No further questions of this witness.
Okay, now we get some cross. I'm going to slow it down a bit.
Yes, thank you, Judge. Detective, I'm just going to start off with some follow-up on this interview that you had with Mr. Anderson. since that was just the last thing you talked about.
Sure.
You had testified just now that you had asked him about taking the registration from his truck, correct?
Yes.
And his exact response was, I don't have his registration card for his truck.
No, he said, spare me the accusations. That was the first thing he said. And then I didn't take it.
If I was to show you a transcript of that interview, would that help refresh your recollection?
Sure.
If I may approach the witness, Judge.
Or do you have a copy for me?
I can show it to you.
You can get your own copy.
Use a transcript and use it as a source.
She's not. Okay, the spiciness in this one is the back and forth between the lawyers and sometimes the judge. Right now, the prosecution is demanding a copy of the transcript of the interview, which he should have already because it was provided for the defense through discovery. So she wants to show the witness a copy of the transcript, and he's like, you can't unless I get a copy. So yeah, the case has been spicy, and it's going to be more spicy. I hear this cross. I have not seen this before. I hear this cross is pretty good. Let's see what the watch says. It's for me. It's for when he gets so tired the state can just say, all right, enough. Already, I did it. I think the prosecutor's voice originates from the top of his trachea, not his diaphragm. It does have a little bit of a nasal type sound to it. Waiting for the internal discussions to end here. He's like, just give me a copy. I think sideways he looks a lot like more Steve, right there. He looks like Steve Martin when he leans forward and you get a profile view. That's Steve Martin. Kesha,
there were multiple points where you had asked him about the registration card for the truck, correct?
That's possible.
And he was adamant that he didn't have a registration card for the truck, correct?
He said he didn't take it.
And in your investigation, was there a state-issued registration card that was ever located in any photo at all for Mr. Gutierrez's truck?
I don't recall.
You had talked about earlier you had reviewed photos from Mr. Anderson's cell phone, correct?
Some. There was 4 cell phones.
So do you ever remember seeing a state of Wisconsin registration card issued to Mr. Gutierrez that was in any of those photos?
I don't recall there ever being a state of Wisconsin registration card involved in this.
Okay. So Mr. Anderson, when he told you that he did not have the registration card for Mr. Gutierrez's truck, you did not have any evidence to support that Mr. Anderson did in fact ever possess the registration card for Mr. Gutierrez's truck.
So I'm going to object as to irrelevant whether there's a Wisconsin registration. This is a Colorado vehicle. So the absence of a Wisconsin registration is irrelevant.
Well, it had Colorado plates. Is it a Colorado registered?
I'm not aware it's registered in Wisconsin or that
well,
that's what we're talking about.
That's not what your objection is.
Well,
I'll rephrase the question to a Colorado registration, if that would, any state-issued registration card.
What's your question?
That you never found any information that Mr. Anderson was in possession of a state-issued registration card for Mr. Gutierrez's truck.
I don't know. I don't know.
Wow.
And let me ask you a question. You're a detective, obviously, right?
Yes.
You've been working, you said 20 years in the force?
Yes.
When you refer to a registration card, normally in your day-to-day business life as an officer, you're referring to a state-issued registration card, correct? As it relates to vehicles.
I guess. What
am
I referring to?
Sure, I guess an example is, did you ever work patrol?
Yes.
When you pull someone over, right?
Yes.
You'd say, hey, can I have your registration?
Okay.
Or when you ask for the registration, are you asking for a state-issued registration card or something else?
Yes, state-issued registration.
Okay, thank you.
Is something wrong with this witness? This
you
is crazy.
also were asked about what information Mr. Anderson had given you about Junior or Mr. Gutierrez, and you said it was very limited, but isn't it true that Mr. Anderson admitted that he had looked up Mr. Gutierrez's information on CCAP?
Yes, he did tell me that.
And you were also asked a question about Mr. Anderson's statements about him being jealous and whether the state had asked you whether Mr. Anderson had expressed any concern about about Miss Beecham dating Mr. Gutierrez. Do you remember that line of questioning?
Can you say that again, please?
Sure. Do you remember the state asking you about what information Mr. Anderson relayed to you as it relates to his feelings about Miss Sadie Beecham dating Rosalio Gutierrez?
Yes, he stated there was some jealousy.
He also stated, I'm seeing somebody else, she's got the right to see somebody else, correct?
He said that, yes.
You were also asked at length about what Mr. Anderson said he had done on May 17th, 2020. And isn't it true that Mr. Anderson in fact told you, I don't know, took a nap, probably. I think I went over to my girlfriend's house, I'm not really sure.
Yes, that's what he said.
And then later he did say, in response to other questions about what he'd been doing the last 2 days, he had informed you that he was tired and really didn't want to blur things together to give you wrong information, correct?
I don't recall him saying that. I know he did say he just didn't remember because his memory is bad.
And what time did this interview happen at?
11:30-ish till just after midnight, 11 o'clock to midnight.
So you agree that it's likely that someone could be tired after all day and then being interviewed at around midnight?
Sure. Could be tired. Oh, yeah, sure.
They're wearing a headset that helps them hear what's going on in court. It's just like magnifies.
Mr. Anderson's interview talked about Stephen Lenz. Remember that?
It's for hearing impaired. Sorry, I'm trying not to talk over them.
Correct.
May I use the Elmo judge?
Yes.
Elmo. We have
Thank
Elmo.
you. And
no Doug, but
you
Elmo.
said that, well, the state asked you that Mr. Lenz would be used as kind of a eyes for Mr. Anderson.
The state said that?
Well, yes. Do you remember being asked that questioning?
I remember the questioning about Mr. Lenz, yes.
And you said that there was communication between them that showed that Mr. Anderson was asking him to look in on Sadie's house, right?
Are you saying that I asked that?
No, I didn't say that.
Okay, because that long string of communication in your investigation doesn't exist, correct?
I didn't say that.
Okay. Did you see the communication between Mr. Anderson and Mr. Lenz?
No.
Okay. So you don't know what they actually talked about then?
I know there was text messages. I don't know exactly what those text messages said. I didn't deal with that part of things.
Okay. Do you remember who did?
I don't know.
I want to go back now to follow up on some things that you first started testifying about. Primarily, when you first got to the crime scene, you had noted that it's important to make sure that you're very careful with how you enter into a crime scene, correct?
That's correct.
And why is that?
We don't want to damage evidence. We want to preserve it as best we can.
And in your experience, you'd agree that when you are processing a crime scene or entering a crime scene, it's important to be extremely thorough.
Of course, yes.
Now, you talked about how Officer Van Wee, some other officers came in, and that they were very experienced in evidence processing as evidence techs, correct?
Yes, they are experienced.
You said they were specialists with Kenosha Police Department, right?
They have the title of evidence technicians.
Now, do you have any specialists that deal with missing persons cases?
Nobody with the title.
So you had noted during your direct examination that you were an investigator in this case, correct?
Detective, yes.
And role of a detective in a case with a missing person is to try to figure out what happened to them.
Yes.
And where they might be.
Yes.
And who may have been involved in the disappearance.
Yes.
So besides Mr. Anderson, who did you investigate as being involved in the disappearance?
Personally, I didn't investigate into anybody else. We did look. We looked for other leads, other clues, other evidence. But personally, I didn't take the initiative to go look specifically at somebody else.
I want to pull up an exhibit. And Judge, I apologize. I'm not going to use the Elmo at this point. The state's kind enough to pull up one of the exhibits since it's already connected. And I'm pulling up what's been previously marked as State's Exhibit 1, Photo 150.
Is the TV on, though?
We're working on it.
Oh, okay. Counselor, you said 150.
150, yeah, thank you.
Looks like it's just kidding.
I just want to make sure the right. Thanks, Jessica.
I've never heard a detective be so unsure about basic information like what a registration card is.
Yeah.
He's having difficulty following the questions, and I agree they're lengthy questions, but they seem like something he should be able to follow. And he's struggling with it.
So you had previously testified about this photo, and you had talked about how there's a standby screen on the TV, correct?
Yes.
And it was determined that that was a standby screen for Hulu, correct?
I believe so, yes.
Did you subpoena Hulu to get the usage records?
I didn't, no.
Could that have been something that you could have subpoenaed for?
I don't know. I have never subpoenaed Hulu.
Okay.
Possibly.
All right. And then did you check the make and model of this type of TV?
No.
So you'd agree that there are certain TVs that have standby modes and sleep modes, correct?
I don't know.
If you left, do you have a TV at home, Officer Detective?
I do.
Your TV, if you turn it on, does it stay on or would it turn off after a certain point of time?
I don't know.
Is it possible that you didn't check to see if this TV had a sleep timer or anything where it would have turned off after a certain amount of time?
I did not check personally, no.
And you agree that that could have been useful information in determining a firm timeline?
Potentially.
And then you had also talked about how there appeared to be some items that could have been knocked off, but you weren't sure. Remember that testimony?
Yes.
And you're not sure because prior to May 19th, 2020, you had never been into that residence, correct?
Correct.
So the items on the floor, it's possible they had already been on the floor because you didn't know how this apartment looked previously.
That's correct.
Thank you, State. I no longer need that exhibit up. Thank you. You also talked about when you looked in and you saw some pooling of blood that you noticed a void, right?
Yes.
And I think you said that that void was where a rug would have been at some point.
That's what it appeared like to me. It looked like a rug had been there at one point.
Did you determine the size of that rug?
I personally didn't.
Do you have any information of whether any officers in the investigation did?
Not that I know of.
But you were familiar enough with the layout of and the size of the apartment, right?
Correct.
It was a relatively small apartment.
I would say that, yes. One bedroom.
Okay. So it wasn't, in your opinion, it couldn't have been like an 8x12 rug.
No, it wasn't that big.
It was more like a 5'7" area.
From what I recall, that seems to be about accurate.
Okay.
Maybe a little smaller.
A little smaller than 5'7".
Yeah.
Okay. And
That's not much
you
to hide a
said that
body
you looked in the bathroom. There was nothing of concern there.
Not that I saw.
You went to the bedroom. You said that there was nothing of concern there.
Not that I saw.
Judge, I would like the Elmo now. I appreciate it. Thank you.
Pictures you showed me before.
Yeah.
Okay, this is getting interesting. I'm sort of concerned for the detective on the stand, like he's having like a low blood sugar moment or something. He's really struggling to follow questions. Electronic lighting machine organization.
Okay. Pulling up what's been previously marked as Defendant's Exhibit 60. From you being there, what room is this?
Appears to be the bedroom.
Okay.
Like the northwest corner of the bedroom.
And the window, do you see the window in the picture?
Can you change the lighting maybe? It's hard to... Maybe we can turn
better?
The light off, Judge, so that...
As you wish.
Ooh, mood lighting. Yay.
You need the light off, or are you good?
I'm good.
Okay.
Can you see it?
Yeah, it's fine.
Yeah, we're good. There's a window in the picture, obviously, right?
Yes.
That window, is it open or closed?
It looks like it's cracked
The
open.
blinds or the window?
The window itself.
Looks like it's one of the panes is cracked open.
Okay. And did you look into that at all? The fact that there was an open window in the apartment?
I didn't look. I guess what do you mean look into it?
So that window, I'll go back a little bit. That window is accessible from immediately right outside that apartment building, correct?
Yes, it looks outside to the north.
So an individual, if they wanted to gain access into Mr. Gutierrez's home, that could be a point of entry into that apartment, correct?
Correct.
We just saw that the window was open, correct?
So I don't know how many panes of glass are on that window or nothing like that, but it does appear as though the window is slightly opened.
Okay.
Yeah.
And that could have been a point of entry.
Could have been.
So you'd agree that that is something relevant in the bedroom?
Okay.
Is
Yes.
it?
Sure, yes.
And it's important when you don't really know what happened to an investigating to determine every possible outcome or situation of how an individual might have gotten into Mr. Gutierrez's apartment, correct?
Correct.
And you'd agree that that's one of them?
Correct.
You talked a little bit about your contact with an individual named Michael Campbell.
Yes.
Do you remember what he looked like?
I don't.
Okay. So you can't remember if he had any facial hair, what his hair looked like?
I believe he had a slight beard. But like I said, it was 2 years ago. I haven't talked to him since. I don't remember.
Okay. And the state had gone into what he was telling you, but he didn't tell you that he was at Mr. Gutierrez's apartment on May 17th, 2020, correct?
I didn't hear that. Yeah, I didn't hear him say that.
And when you were with Miss Beecham, questioning and talking to her, at any point did you observe her on her cell phone?
I may have. It's possible she used her cell phone.
Was she talking to anyone?
I don't recall.
Okay. Moving to your observations on Mr. Anderson's property, and you said you looked into the van, correct?
Correct.
I'm going to ask you some follow-up questions on that a little bit later.
Okay.
You looked in the dumpster. There was nothing of evidentiary value found there, correct?
Correct.
And you had noted something interesting, that you located lath in the dumpster?
Yes.
And in your investigation, you were aware that Mr. Anderson was doing lath removal at a house in Belgium, Wisconsin, correct?
Yes.
And you said there were other areas on the property, and just in a whole, you did not find a body on the property, correct?
Correct.
No human remains on the property, correct?
Correct.
You talked about the flannel shirt, and if the state would be so kind to pull up that Exhibit 40. Oh, no, I think I got it, Jessica. Thank you. I'm going to, for record purposes, pull up State Exhibit 42.
Now she's taking Jessica's job.
When was this picture taken?
I don't know.
This picture, wasn't taken on May 17th, correct?
Correct. I believe it was older than that.
Much older, right? And you don't have a single photo of Mr. Anderson wearing that shirt on May 17th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 18th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 20th, 2020, correct?
I do not.
And you said the state had asked you about whether you searched the house and if you found the shirt. You said you had not, right?
We did not find the shirt.
Did you search Christine Remsburg, Mr. Anderson's girlfriend's house, to find that shirt?
I did not.
Did you search Miss Beecham's house to see if that shirt was there?
We did not.
So the only place you looked for that shirt was at Mr. Anderson's home?
there, the house in Belgium, a tree farm we looked. Yeah, those 3 places.
Okay. But you didn't, there were places that you could have searched for it and did not, correct?
Potentially.
Okay. So I'm happy you brought up the house in Belgium. Were you involved in searching that residence?
Me along with several others, yes.
And are you aware that the state believes that Mr. Anderson, I guess, chopped up Mr. Gutierrez's body at that residence?
Objection calls for a conclusion that I don't think is in evidence in this case.
I can rephrase and ask a better foundation question. You have no idea where Mr. Gutierrez's body is, correct?
Correct.
And you have no idea how his body, or where his body is now.
Correct.
That's the same question.
And in fact, he's still technically considered a missing person, correct?
Objection, how would that determination by some mystery person be relevant in this case?
That does...
It's fine. I'll withdraw the question and continue on.
That one's
Judge.
for the state. That's a win for the state there.
In your investigation, you were unable to determine what, if anything, Mr. Anderson had allegedly done with the body, correct?
Correct.
So when you went to the house in Belgium, you found absolutely nothing of evidentiary value, correct?
It's got 11 to 9.
Objection, that would call for a conclusion by the detective.
Sure, I'll go into it differently, Judge. You found no human remains at the house in Belgium, Wisconsin, correct?
That's correct.
And you know that this, in your investigation, you're aware that Mr. Anderson had been there the morning of May 18th, 2020, correct?
I know that at some point he was determined to be there. As far as the exact date and time, I don't know.
Okay. And you found no blood evidence or suspected blood evidence, correct?
At that house?
Yeah.
No.
Did you find any trash bags filled with body parts?
No.
Okay. Did you find any bloody knives?
No.
All right. Did you notice that the property was under construction?
Yes.
And did you see that there, I don't know your expertise in the line of contracting work, but you had testified you had seen lath at Mr. Anderson's home. Did you see things consistent with lath removal at that property in Belgium, Wisconsin?
Yeah, it's likely that's where the lath came from.
Okay. You noted, I want to move back to Mr. Anderson's property. You said that you had looked into the black van, correct?
I did.
And you noticed that the van carpeting had been cut out.
Yes, is missing.
Missing.
The woman in the light-colored, dress suit is
You cannot definitively say your
defense lawyer.
investigation didn't produce any definitive answers as to when exactly that carpet was cut out of that van, correct?
Well, objection. His investigation does have witnesses that put a time on that.
Well, then he can answer the question. I think it's a totally plausible question.
Why would he be charged with that knowledge?
I'm asking him if he knows.
Well, he can answer if he knows.
Correct.
win one for the prosecution.
Yes, I know.
Or for the defense.
I know. We have it narrowed down to when it was removed.
And that was solely based on statements of another witness, correct?
Correct.
It's not based on photos of Mr. Anderson removing the carpet, correct?
Correct.
And there were no other witnesses that could corroborate that one witness's statement, correct?
Correct.
You talked about some duct tape and rope. That was also from a single witness, correct?
Correct.
You were not provided any photos of that duct tape and rope, correct?
That's correct.
And you had never observed that duct tape and rope prior at Mr. Anderson's home?
No, I didn't.
The state, kind of going back to the cross-examination or the direct examination on Mr. Anderson's interview with you, had talked about asked about Mr. Anderson not really admitting to which car he drove, but he said he drove the Audi and the van, correct?
Said he primarily drives the Audi. He doesn't really use the van.
Did he say he used the van for work purposes?
Yes.
And your understanding is Mr. Anderson's work is as a contractor?
Well, can I approach?
If there's an objection, they can state it.
If there's an objection.
I think the question opens a door to this officer. He has some knowledge that question. I guess I have no objection. The question was asked, what is his current job, or what's his source of income? That is
exactly, but
that question's been asked. Let's let it be answered. I don't object.
Why are you talking?
All right, everybody's on board, so
you go ahead and answer.
Well, if we can have one moment.
Huh. Now the prosecutor's like, hang on, what might be coming in? We're not quite sure what is going on. They're conferring amongst themselves to see if they want to let some information in. The prosecution initially started objecting and then said, no, never mind, we don't object. We would love to hear this. Please proceed. But we don't know what they're getting at.
I'm going to re-ask the question.
Judge, there was no objection. Can't he answer the question?
Do you remember the wording of the exact question, officer?
Yeah, what he did for work?
Well, were you aware that Mr. Anderson was doing contract work at that time?
Yes.
And there was evidence that Mr. Anderson admitted to that proves that he was driving the Audi around this time. Primarily that he was driving the Audi on April 24th, 2022, correct?
This guy's like...
I don't know if he specifically told me that. He did say he was operating a car that night.
Right. And that was confirmed by other witnesses?
Correct.
Yeah, it's just warming up. This is going to get better and better. This is why we're going to have so much fun on this trial. Yeah, Gabrielle, we're not sure why there would be that much as well. Clearly, there's something that this detective knew that the next question could have opened up the door that would look really good for the prosecution and bad for the defense. But let's see. I like the way she says Audi. Far too expensive for a lady for me. Expensive for a lady for me. The Audi is one of the terms that's been mispronounced several times during this trial. It's been pronounced Audi, which I think is a crime in and of itself. Hey, Jim S., welcome. Good to have you here. Thanks for admitting to being an addict. I think you just click the subscribe button. But it's the same thing.
Up on the screen. Do you recognize this?
Hey, we got pictures. Here
yes.
we go.
Okay. And that was a pizza box and receipt that was on the stove at Mr. Gutierrez's apartment, correct?
Now I'm thinking about pizza.
Yes.
Did you investigate this at all to see when this delivery was dropped off?
I did not.
Do you think that would have been useful if it was dropped off, let's say, on the 17th at night to talk to the delivery driver?
Potentially.
Because that delivery...
If it was, I don't know when it was dropped. I didn't look at the receipt.
But there's potential investigatory points that could have been covered in investigating this?
Potentially, yes.
And it wasn't, correct?
No.
Are you indicating that nobody did this, or he did not personally do this? Objection as to vagueness. I don't understand the question.
You can cover it on cross or redirect.
Okay.
No, that one's for the prosecutor. That was for defense.
I didn't investigate it.
Okay, and I'll just ask the question the state wants to ask, which is, are you aware of any other officers investigating this?
Huh?
So I'm going to object because it implies that he would know if other officers did. No one has indicated that he would have some overall supervision of this investigation, Judge.
He's previously testified that he was one of the lead detectives in this case.
Well,
I don't believe he had.
I never said that.
I never said that.
He testified that when he arrived
3 weeks.
there was one other detective who was there, but I don't recall any testimony that he is saying that he was the lead detective, but I don't know if he did or not.
Were you aware of other tasks, other detectives and officers?
That one's for the prosecution.
Some.
Okay, and the some that you do you know if anyone investigated this?
I don't know.
Okay, thank you. Showing what's been marked as Defendant's Exhibit 61. You're familiar with the fact that, well, let me strike that, rephrase. Did you look at the dumpsters in Mr. Gutierrez's or near Mr. Gutierrez's apartment?
No.
Are you aware that that happened?
I don't know.
Okay. You were at Mr. Anderson's home, correct?
Correct.
You looked around the property, you said before, right?
Correct.
It says marked as Defendant's Exhibit 76. Did you notice the trash bags up against the barn at Mr. Anderson's home? I'll zoom in for you if you need.
There's the body, I guess. Must have been in the trash bags.
I don't recall.
Okay, but you'd agree those are trash bags in this photo, right?
That's what they appear to be, that, yes.
Okay, great. Then you said when you were at Mr. Anderson's home, you had looked into the van, correct?
Through
Did you
the
look
window.
at the front window too?
I believe I made my way all the way around the van.
Okay, so I'm going to show you it's been marked as Defense Exhibit 62. Is this an accurate depiction of the front seat of Mr. Anderson's van?
Appears as such.
Okay, and there were tools in his van, correct?
I believe so.
You'd agree that those are tools or a toolbox of some sort on the front passenger seat?
Yeah, tape measure, tools, looks like a tool bag.
Okay. And you'd agree that there's a lot of cluttery stuff around there too, right?
What is that
Yes.
noise?
Okay.
Is the judge playing a game on the phone?
I'm going to show you what's been marked as Defense Exhibit 65. This is another view from the behind of the vehicle, correct?
Correct.
And you'd agree with me that there's a lot of dirt and stuff on the floor, correct?
Looks dirty.
Looks dirty. It hadn't been vacuumed or meticulously cleaned, correct?
Doesn't appear as though.
Okay. I'm going to show you another picture of the front, Defense Exhibit number 66. Again, lots of items, correct?
Yes, very busy.
And this is how it appeared to you on, was it the 20th of May?
Yes.
Okay.
It's a mess.
And another angle of the front seat taken from the passenger, Defense Exhibit number 67. Again, lots of items, correct?
Yes.
And this is how it appeared to you?
From what I recall.
Okay, great. Showing you more pictures of clutter here.
Yeah.
Defense Exhibit 68. This is the front of the vehicle, correct?
Yeah, between the two front seats, looks like.
And we still see a lot of that clutter?
Yes.
And that's how it appeared to you?
What I recall.
show you another picture from inside the van.
Guys,
Defense
like,
Exhibit 69.
that's where I put it.
I think you can see that dirt and trash a lot more clearly, correct?
Yes.
Does this look like a car that has been cleaned to you?
Doesn't appear so.
You said you also went to the tree farm to help with the search that was executed there?
Yep.
And you're aware that there was a burn pit at the tree farm?
Yes.
And multiple agencies had come to process that burn pit, right?
Yeah, there was approximately 100 people that took part.
And you were able to confirm that there was a controlled burn there on May 8th, 2020, correct?
I believe that was the date. Yep.
And that the owners of the tree farm had alerted the Ozaukee County Fire Department of that burn.
I believe so, yes.
Okay. So I'm just going to show you some pictures. This is Defense Exhibit number 70. This is part of that linear search of that burn pit, correct?
Yeah, so I didn't take part in most of that search. I was doing other things.
Okay,
but that looks like the burn pit, and that looks like what they were doing.
Sure.
Searching.
So maybe I'll just ask you then, you were aware that that was a large operation?
Very large, yes.
And they didn't find any human remains there, correct?
Not that I know of.
And they didn't find any bloody evidence there, correct?
Not that I know of.
Okay. Back to Mr. Gutierrez's home, I'm going to show you what's been marked as Defense Exhibit 58. The number of his apartment building, 3709, that you can see that in this exhibit, correct?
Yes.
And that 3709, you can see that from in the parking spaces right in front, correct?
Yes.
And you had been at this scene during the day and at night, right?
No, I was there during the day.
Not at night? Okay. As part of your investigation, you talked to an individual named Kim Lavora.
I did? Kim Lavora?
He's like,
She also goes by Undendum Lavora. I can go get your reports if that would help.
Yeah, you need to clarify that one.
Yep.
We talked to a ton of people.
Yeah,
so.
no.
Counsel, I'll stipulate to the record if you just want to do that. You're not going to ask what he asked or anything.
Correct.
So I'll stipulate rather than, if you want to refresh, you can, but if you just want to.
I do want to refresh.
Okay.
Thank you.
He would stipulate, but instead, I don't know why they don't want the record brought up there. There might be something in the record, in the transcripts, that they don't want brought in. Burn San Andreas fault. It was a big burn pit. It burned the Continental Plate. Wisconsin burn pits are other people's bonfires.
You could hold those ones in the red file till tomorrow.
Yeah, the lead detective thing, that was a miss for her. It was a swing and a miss. I didn't hear the lead detective comment either, just detective. He's one of the detectives. Chris, you bought a jar of spicy maple bourbon pickles. Chris, that is awesome. I will tell you, before you open them, resist the urge to try them right away. Throw them in the fridge. Let them chill for a couple hours, and then give them a taste. And I think you'll like them. Prosecution's going to want a copy of the entire thing. Yeah, OCD and that van, they don't go well together.
Kim. Oh, Umdung. Okay.
Umdung. Okay. Tough names.
Counsel, for purposes of the record, you don't want him to read it out loud. You're just
No,
refreshing his memory.
For purposes of the record, I've handed the detective a copy of his own report to refresh his recollection.
There's a very small blood spot in the van that contains the victim's DNA.
Were obtained in this case from Mr. Gutierrez, correct?
Yes.
And going to show you what's been marked as Defense Exhibit 75. Probably going to have to zoom in here and focus, so bear with me.
Well, given the hour.
This is going to... Go ahead, Judge.
Well, if this, it's going to be brief.
With this point, yes.
We're going to take a break.
Well, I know that. I wasn't going to end your entire examination. But it's 1 minute, 3 minutes.
This will be like 1-2 questions max.
All right, I'll hold you to
Okay. I won't disappoint. So this phone record shows that these are Mr. Gutierrez's phone records, show that he called a Kim Facebook on 5/17/2020 at 8:49 p.m., correct?
Appears as though yes.
And that when we look further up, there's a duration column, and the duration of that phone call was 17 minutes 4 seconds, correct?
Appears as though, yeah.
I lied. I have 3 questions, Judge. So if
Now we're
there's a phone
disappointed.
call that started at 8:49 that lasted 17 minutes, that's going to put that phone call to approximately 9:06 p.m. I'm terrible at math.
Yes.
Okay. Thank you. Judge, if you wanted to take a break.
Well, I'm only doing it for others. But let's take a break, and please don't read, watch, or listen to any account of the trial. Discuss the case with anyone. And let's aim for about a 15-minute break. Any questions? Okay, thank you.
Okay, so we're going to skip ahead just a tiny bit here as they take a break. I will say this. We have 2 hours left of video for today's trial to get all the way caught up. Not to get all the way caught up, to get caught up with day 3. I was going to watch it on higher speed than what we watched this on, if that's okay. Any objection? Hearing none? Just kidding. I'll give you a second to think that through. Okay, we need to come back at, checking the timestamps, 6:08:22. Okay, so we're coming back here to the trial here in just a second. Higher speed, we're going to go 1.25. Engage ludicrous speed, says 6-volt bus. We're going to get through this as fast as we can. So we've got now like a 2-hour block to finish. Who did he call? Who call on those phone calls? Like, are you talking about the judge? The judge calls the like the person who manages the jury. Okay, higher speed, we're good with that. All right, we're gonna take it fast and try to get caught up. We're going plaid. We're moving quick here. Adam, go for it. You've got other work to worry about. I'm surprised you could even keep up with what we're doing today, Adam, as the owner of the internet. Did the victim and the defendant know each other? Yes, they did. No, there was no reason for him to. Well, defense has a reason.
Shall we begin?
We're going to hear about that. It was covered a little bit in the opening statements. I think we all need to see a cute puppy photo. We need to show a Bite Me's photo. Rebecca sent me these pictures. Judge is surfing the internet on his phone.
Hello. Would you come down, please? Yeah. Thank you.
It's like, what kind of phone is that? Is that like a flip phone? What is he using?
want the officer, you want the detective to go back on the stand?
Yes, please.
Yeah, going back up. Yeah, sorry.
It's just swiping. Scrolling through Facebook. You can see it's just scrolling up. It's a brick phone. Appears to be an iPhone 4. No, it folds open. Did you see? He just opened it. Maybe a BlackBerry. It's a Game Boy.
Bring the jury.
Thank you, Judge Newman. Appreciate that. I'm getting these pictures moved over. Bite me. So we're going to show the puppy pics. Jury has to run down the stairs every time he calls him.
Weird.
Yeah. Okay. Yes, go ahead.
Thank you. All right, I'm pulling up what's marked as Defendant Exhibit 63. This is picture of the dash in Mr. Anderson's van, correct?
I'm going to object, Judge. The detective has indicated he took a brief glance in without entering the van. I don't believe he's a witness who would be able to talk about details of the of areas of the van that are not the cut area in the back or the bleached area that he's testified to. So this is a close-up view. He says he took a brief glance. I don't think he's a qualified witness to testify to this exhibit.
He can respond if he doesn't know the answer.
Okay, that's with the defense.
I don't know what that is.
Okay, that's fine. That was 63.
That was a really bad photo. You're right, Ann.
I'm going to ask you about some dates and what you reviewed. If you need your recollection refreshed, just let me know.
Okay.
Do you remember on May 25th, 2020, reviewing video footage from a High Line gas station?
Yes.
And that gas station was located near Mr. Anderson's home, correct?
Judges,
I believe it was at the interstate near the tree farm.
Okay. And so if it was in Ozaukee County or Sheboygan County then?
Ozaukee?
Okay.
I'm guessing. I'm sorry.
It's fine. I could give you the locations you put in your report. I don't know if that would help. You said
Please.
Located at Interstate 43 and County Road D.
Correct.
Okay.
Yep.
So Ozaukee County?
Yes.
And the reason that gas station was important was because if Mr. Anderson had traveled to the tree farm or back from his home, he would have passed that gas station, correct?
Objection. The detective would have no ability to know the route that somebody took to get to someone's home. Presumably there's a number of highways, number of roadways.
I'll rephrase it. Why was getting and reviewing the surveillance video of that location important to law enforcement in this investigation?
It was a potential route of travel.
Okay. And you reviewed several hours of video, correct? For the High Line gas station.
Yes.
And you reported that you did not see Mr. Anderson's black minivan, correct?
So the cameras were a substantial distance from the road, and at nighttime it was almost impossible to tell what cars were going by. So I don't know what cars were going by. No, I didn't see a black van drive by.
And in your report, you were clear that you reviewed several hours of video and did not see the black minivan.
Correct.
You also indicated that on May 26, 2020, you continued to review video surveillance, correct?
Of what? What surveillance are we talking?
Yeah, I was hoping you could answer that. Can I show you your report?
Sure.
That's a good question. What were you looking at?
Okay.
Sure. So
Did that refresh your recollection?
yeah, so we had hours and hours and hours of video from multiple locations we took.
Just sent a super sticker with 5.
Hey, thank you, Smoky
I
Mountain
didn't document
Lady.
what I looked at there.
Appreciate the super sticker.
But we
Mic drop.
reviewed several locations. I don't know specifically what I was talking about when I mentioned that in my report.
But is it a fair guess that those were locations of interest due to potential traffic patterns of Mr. Anderson?
Potential routes, yes.
And in your report, you noted that you observed nothing of evidentiary value, right?
Correct.
And can you explain to the jury what nothing of evidentiary value means?
I saw nothing regarding a black van, a black Audi, or anything related to Mr. Anderson.
I have no further questions subject to redirect.
I'm going to start from the back. So you were just asked about some video that it sounded like it was a gas station location that you looked at?
Yes.
And that appeared to be on May 25th, 2020, correct?
Correct.
You wrote a report that memorialized those fascinating hours, I assume, right?
Yes.
Counsel read to you, I reviewed several hours of the video and did not see the black minivan. Do you recall that just being read to you?
Yes.
Is the next sentence in your report, however, the video was from a great distance, making it difficult to make out traffic, especially during the hours of darkness. Is that what you say next in your report?
That's what I testified to as well.
And so when counsel read to you the first sentence, you had already also tried to testify as to the second sentence, and it's also in your report. Is that right?
If you just read it, it's in the report.
You have no reason to dispute it. Would you like to take a look?
Sure.
I'm going to object. This witness has already testified to that contents, and the video was poor quality and it was dark.
Well.
Yeah. What page? Wait, actually, Mike, what page is that?
I can't tell what the ruling was on that one.
So I'm just going to ask you to take a look at
It looks
your
like
report
it's
and ask you,
State
do
got
you
that one.
agree that after the first sentence that was read, there's
almost
the second
tied.
sentence, and it's what you testified to?
Yes.
Okay, so it's also in your report. Is that right?
Yes.
Is tied. Okay, I wasn't keeping straight. Thanks, DMB. I've got 13 to 12. Am I off?
You were shown on the
Defense
doc cam
is
just a
13.
minute ago, or I'm sorry, before the break, the signage indicating what the 3709 address for apartment 1B. Do you recall that?
Yes.
And that picture was one where you said that the sign was visible, correct? Like would be visible from the road.
Yes.
Do you recall
From
testifying?
15th Street. Right? From the road.
That's it?
Thanks, DMB. Appreciate the gracious concession.
And again, does that appear as best you can see to be, of course I forgot that you got to do that. Does it appear to be a daytime photo if you can tell?
It is.
Okay. At nighttime, would you expect there to be substantially different visibility?
I'm going to object. I asked this witness if he had been there at night, and he had said he had not. So it would be purely speculative.
Oh, I think he could. At night, would you expect that signage to be significantly more
State won
difficult
that
to
one
read?
as well. Now it's tied 13s.
Believe that to be a safe assumption.
Okay.
It's dark.
And on the 17th of May, do you believe it to be heavy? Was it heavily raining?
Yes.
Was it heavily raining at night?
Yes.
Have you, and so if I add in heavily raining at night, would you expect the signage 3709 to be different and more difficult to read than it is in the current state of the daytime photograph?
Rain would obstruct the view of the sign at night.
You were shown a picture. It is Defense Exhibit 65.
I had defense ahead.
Where you were asked if whether the van
over here.
And
These
this
were
is the
reversed.
defendant's van, as best you know, correct?
Correct.
You were asked if it appeared to have been meticulously cleaned. You recall that?
Yes, that's what I was asked.
Okay. Now, this is not the same view you saw. You saw the van during the day, for instance, correct?
Through a window, yes.
When you saw it, did it appear to have been selectively cleaned as opposed to comprehensively cleaned?
Yes.
Okay. And what left you to the conclusion that instead of someone comprehensively cleaning the van, and have you ever cleaned one of your cars?
Yes.
Do you normally, detective, clean only small portions of your car? Say, if you have a minivan, you only clean the back third?
Typically not, no.
Would you use bleach on just certain locations, or do you typically clean the entire automobile if you are engaged in your normal activity?
I'd clean the whole automobile and I wouldn't use bleach on the carpet.
Okay, so when you observed what appeared to be bleach stains and the back cut out, was it your sort of at least beginning conclusion that somebody had made some efforts to do something to that minivan that wasn't involved in just trying to keep it clean.
Yes, it definitely wasn't normal.
I'm going to show you
Thanks,
what's been
6 Volt
marked
Bus.
as State's Exhibit
Appreciate your
59.
support. Congratulations on the 3rd month
Do
there.
you recall this pizza box from your walkthrough of the scene?
I know there was a pizza box, but like my walkthrough was what it is.
Did you bring the pizza box?
Stop and do crazy examinations. I didn't evaluate evidence. Well, I walked through the residence to get a gist of what happened.
So I guess I'm going to ask you plainly. Are you the best person from the Kenosha Police Department to testify as to each of these areas or items and whether anyone collectively on this investigation did anything further? Are you the ideal person to ask those questions to?
No.
For instance, if a officer called the pizza place and made some determination that this was not an issue in this case, in other words, in terms of the timing, would you know that one way or another?
No, I know some things. I don't know others. I didn't lead the investigation. I assisted.
I want that quote.
Fact
I know
asked.
some things, I don't know others.
If an officer made that call and determined it was not an investigative lead, do you know that or would you know that?
Not necessarily.
Okay, and in this case, do you know that?
No.
You were showed a picture that is defense exhibit, 76. Do you recall this?
Yes.
You recall that it was, I believe it was honed in and there's some garbage bags along the side of that particular building. Do you see that?
Yes.
And you were asked whether that was something you personally had reviewed, I believe, correct?
Something to that extent.
Are
This
you
guy
aware
flaps his arms much
that
more,
in the
he's gonna
context of
take
this
off.
investigation that those garbage bags were the remains of marijuana grow? That they are potting soil and other remains from a marijuana grow?
I'm going to object on the grounds that one, speculation, lack of foundation. As he already testified, he did not look at those bags, look in those. It's also an argumentative question.
Well, counsel brought it up. I didn't open this door. He's either aware that that's what the contents of the bag are or not. That would lead a reasonable jury to decide, is this an investigative lead about a missing body? If it's bagged with potting soil for marijuana, then it would be reasonable to conclude that's not that's not necessary in terms of this investigation.
Well,
Puppy's name is Princess Buttercup. Scott will show the photos when he slows the circus down, face rolling on the floor laughing, red heart card soup face rolling on the floor laughing.
Yeah, which is what they asked.
These are the pictures of Buttercup, Princess Buttercup,
investigation is
for Bite Me. Got a couple of them here.
of separate
There's the first one.
inquiries. And if having an adequate investigation also involves proper coordination of various reports and observations. So you're asking him if he is aware.
Right. Which is my redirect question.
Thank you very much.
Their specific
Bite me.
cross-examination.
Love the
I'm
pictures.
using the same phrasing. He's either aware of it or not. If he's unaware of it, obviously I would have to put in any affirmative evidence of it with some other witness. But this is a question of whether he's aware, because the topic, I assume what my redirect is directed at is, if I'm correct that these are marijuana potting soil bags, a quantity of them, then obviously they don't have an investigative lead quality here. And again,
That's argumentative.
Apologize, they brought it up. So
Now the objection is sustained.
Sustained. This one's for the
as to his
prosecution.
awareness. The question is to his awareness.
Or for the defense.
Okay. All right. You were asked by the defense on cross-examination, counsel, on whether there was any videotaping of the defendant cutting the carpet out of the van. Do you recall being asked that question? Whether there was any videotape available of him, of the defendant cutting the carpet from his van during this period of time, or pictures, either
No
video
photos.
or pictures.
Yeah, there was no photos.
Okay. Would you expect someone who is trying to remove blood evidence from their van to videotape themselves or take pictures of themselves during that process? Is that something you would expect?
I'm going to object. This question is tending towards argumentative.
Sustained. One for defense.
Yeah.
The audio and video is in sync.
You were asked whether on cross-examination
But his
whether
mouth sometimes
Anderson's
starts
home
moving
had
before
any
he
body
talks.
parts at its location or any other blood evidence. Am I correct that the search warrants at Anderson's home were 2 days and 3 days after the time you believe that Mr. Gutierrez was murdered?
Yes.
Okay. And do you have any specific reason to believe that at any point that Mr. Anderson either stored the body at his home or did any of the blood work at his own home? Do you have any reason to believe that?
No, we found nothing to suggest that.
And so, again, would a person having 48 hours to no longer be in possession of the body of Rosalio Gutierrez or of any of the blood evidence, would a person have enough time during that period of time to either not have that evidence at their home and also to dispose of that evidence? Is that a sufficient amount of time?
I'm going to object. This is beyond the scope of my cross-examination. And it's also argumentative.
As to the first objection, as I think I commented the other day, I am always hesitant to limit an examination as not within the scope, unless it's really things that ought to have been fully covered earlier. So I'm going to overrule you on that. On the fact that it's argumentative and speculative.
I thought the argumentative objection is me being argumentative with a witness. I'm not aware of argumentative being that there being another form of argumentative. I thought it
There
meant
are
to be
two forms.
Okay.
One is arguing with the witness, which is really is a branch of things that ought to be taken up in argument, and the lawyer is simply attempting to
So I think we're going to have a one-on-one.
Testify in a way which is a substitute for the argument. That's really the principal problem with argumentative questions, but it can be both. But it's also speculative. I mean, I think your question is, and correct me if I'm wrong, I think your question is, how long does it take to dispose of a human body?
Or, well, not how long, but can it be done in 48 hours before this search warrant is done?
Don't know.
Well.
I don't.
Okay. Okay.
Okay, so one-on-one. One for defense, one for the
I've
state.
had lots of pathologists up here, and who will probably have it before this day is or before this case is done. Oh no, we won't. No, not in this case. But that would be speculation.
No pathologist.
As to how long it would take to dismember.
Because there's no body.
Or otherwise dispose of a human body.
Well, I mean, I'm not aware of any specific evidence that there was a dismemberment. One can just bag up a human body and place it in a dumpster.
Also true.
Okay.
Well, but dismemberment might be the more
listening.
efficient way to do it. I don't know.
Start discussing how to get rid of a body.
So, go ahead. No, but the objection is sustained.
So, you were asked whether you saw a picture of the defendant in a flannel shirt. Do you recall that?
Yes.
And when that picture, and you don't know when the date of that photo was?
I don't.
Your reason for focusing on that flannel shirt is you have multiple witnesses who told you that just hours before Rosalio Gutierrez is murdered, in your belief, that he's wearing that shirt. Is that correct?
I'm going to object again on argument and grounds and foundation. There's been no testimony as to what time it's believed that Mr. Gutierrez was murdered or went missing.
Well, the problem I'm stumbling on with the question is what the detective's belief is. As I say, this gets into the argumentative, the subject we were just talking about. This is really part of your argument later in the case that is attempting to be extracted from the witness. And the witness, in order to respond, it seems to me has to employ a lot of speculation.
Well, he has a working theory as to when this occurred. And he is, remember the flannel shirt is a focus of the search.
Right.
Okay? So the cross-examination question was, well, you're basing this just on two witnesses, you have no photo at the time. So it is redirect to say, well, you have two witnesses and they are close in time because we have no photograph of him that day. They are close in time to your working theory of when Rosalio Gutierrez is killed. So that counters with his testimony that his basis of focusing on the flannel shirt is that multiple witnesses say just hours before Rosalio Gutierrez is murdered per his working
father and
theory,
brother
based on electronic evidence,
behind
etc.,
him.
that they see him wearing this flannel shirt. So it's not remote in time, which is the suggestion of the cross. And so the redirect is to show that, not that it's true, right, but that he's been provided information that it is recent in time.
If I may respond?
All right.
Thank you. First, if the state wants to ask, do you have a theory about when Mr. Gutierrez went missing, then that's the proper question to ask to lay the foundation for the series of questions, not to ask a speculative, argumentative question without laying that foundation. I have not heard any testimony from detective about his theory of when Mr. Gutierrez went missing or was killed. So again, I maintain the objection.
Counsel and Cross did not ask any foundational questions in that regard either. Why would he have to explain the theory if he's simply indicating it's near in time?
Well, given the opening statement that was made by the defense,
yeah.
I think that the existence of a, quote, working theory, unquote, may be a line that you might want to pursue and could, but that's not entirely clear thus far. And number two, the way it's being presented is, in my opinion, argumentative, and also it's speculative.
Okay.
The objection is sustained.
This win for the defense.
When were you told that the two witnesses who are your source that the flannel shirt was being worn, what was your understanding of the time that they indicated they last saw the defendant in the flannel shirt?
I believe it was around 4 o'clock Sunday.
Okay, Sunday is May 17th?
Yes.
And are you a person who has knowledge of the electronic evidence of this case, at least in the general sense?
I know some.
Okay. And on the same day, is Mr. Gutierrez believed, based on the electronic evidence and his absence of any more responses after, is he believed to have been killed at a time in the area of 10 p.m.?
I'm going to object. This is already extremely leading.
What do you say?
Between 9 and 10 p.m. on the same.
Wait a minute.
I apologize. I thought you said yes. I apologize.
Oh, I'm sorry. I said it seemed it was leading.
Okay, I'm on redirect.
Right.
Okay, so I'm trying to direct him to the place that the court asked me to. The only other avenue I would have to ask this question is to ask him to explain what time, when he is not the detective who formulates that.
The objection to a leading question is based upon the fact that is suggestive of the answer.
Yes.
And the form of your question was suggestive of the answer.
Sustained. Another one for the defense.
What time period, in your knowledge, detective, is the time period where it appears that Rosalio Gutierrez has been murdered?
Between 9 and 10 on Sunday the 17th.
That's the same day as as you've indicated, around just before 5, that the two witnesses saw him in a flannel shirt that seems to match the picture.
That flannel shirt, yes.
You were asked whether Michael Campbell had offered you information that on May 17th that his phone was at the home of Rosalio Gutierrez at some point. Do you remember being asked that question?
Yes.
And you knew that Michael Campbell was a friend of Rosalio Gutierrez?
Yes.
Did it cause you any concern that that his friend did not tell you that he had some contact with his residence on some period on May 17th?
No.
And are you aware, pursuant to this investigation, that contact that they're speaking about is actually at 1:45 a.m. when you have just indicated that your thoughts on this case is that it would be 20 hours later, 9 or 10 p.m., that Mr. Gutierrez is murdered? So it would be 20 hours earlier. Are you aware of that?
No.
You were shown a picture of the bedroom of Rosalio Gutierrez. Do you recall that picture?
Yes.
And that picture had a window in the far side of it, correct?
Yes.
Are you also aware that the reports in this case is that the slider that would face the street was also found open in this case?
Yeah, I don't know.
Oh, you don't know? Okay.
I'm sorry, the sliding
door
in the living room.
Yeah.
I thought we were talking about the bedroom window.
I apologize. I meant the sliding door in the living room. Are you aware that was found open?
That's what I was told, yes.
The screen was closed?
Yes.
That's what I was told.
So that would be another logical method of entry, correct?
Yes.
Simpler method of entry than climbing in a window, correct?
Yeah.
The blinds were in no way disturbed that you saw in the picture, were they?
Not that I saw.
And did that picture include notes on it? I'll show you.
I believe on the pillow on the bed.
I'll redirect you there.
Judge, if I can have a sidebar on this issue of line of questioning.
You probably haven't had an opportunity to see all of my Brewers pictures in the bag. So why don't we take 5 minutes and we'll be able to do that. Opening day is coming. So please don't talk about the case during this very short break.
He's talking about his hunting pictures? Is that what he said? So they're going to have a little bit of break here. Let's see. I'm not. If the jury's gone, we might have the discussion on mic. That's what I'm hoping for. Yeah, this is. It sounds like we're using the wrong witness to get some of this information. He just doesn't know what this is, what's going on. What pictures? He said something about opening day is coming, so it's got to be either fishing or hunting. I don't know if some states have hunting seasons, some states have fishing seasons. Apparently, the judge has a bunch of pictures of whatever it is.
The last 2 years, there hasn't been much demand in my group.
He's talking about some, I don't know, a Facebook group or something. Ivan, I'm going to have to see a picture of the muskie that got you on the board there. Or was it a series of muskies? Was it like a competition, overall weight? I'm going to need to know more facts on that.
The preemptory position that the defense was noting here is there is a piece of paper on the pillow on the bed that's a note from Mr. Gutierrez's daughter. The defense's position is that the contents of that note are not relevant to this case. I could see the potential argument that the state would want to make by introducing that there's a note on the pillow if they're going to try to loop in that, oh, he must have not slept there then that night of when it was put there. That's fine, but the defense would object to going into what the note says based on the fact that it's not relevant, and the defense's position would be that the introduction of what's in that letter would be simply to garner sympathy and appease to the emotions of the jury, which would be inappropriate.
They find a note at the murder scene?
I intend to just simply indicate the first thing the counsel said. I did not intend to ask about the contents of the note. I just intended to ask, is this a note that was determined to be a note from the daughter? When was the daughter there? She was there Sunday into the afternoon. And that is a piece of evidence that the bed was never slept in after May 17th. So I didn't intend to go through the content. In fact, I'm not sure he'd be able to read the content of the note. So.
And I think, too, I mean, there's no evidence if it's from her daughter, the daughter, or the son. So as far as who the note's from, I think, too, is irrelevant. I think if the state wants to say there's a letter on the pillow, that should be the extent of the inquiry.
It's signed. It's signed by the daughter, yeah.
Well,
and again, I'm not going to get in the content because I don't want her name to come up other than that it's the daughter. But again, I think it is another way to time this out. This isn't, this is an exhibit introduced by the defense for this witness. So obviously we have other witnesses coming, but I think it's valid redirect.
Well, here's the problem, and I'm not criticizing anybody. This case is coming in with an enormous amount of evidence, which ordinarily would be totally inadmissible. And you said it a moment ago when we first started talking about this, you referred to it as a note which has been determined to be from the daughter. So there's some more that we're not apparently going to get into, but it's an example of how things, without any sponsorship, are getting into the record. And it really is bothering me quite a bit. Now, I'm not saying anybody's done anything that isn't right, but the sooner we can move into what would ordinarily be received as circumstantial evidence, the better. Apparently, this is not a problem which is going to torment us.
They're like hearing aids. They amplify
so I'm
the
not
sound.
going to worry about it, but just make a timely objection if you think something's going on that oughtn't. Okay? Now, let's let the jury know.
Can we get a ruling, though, on the scope that the state can go into as it relates to that?
As I said before, I really can't pre-screen.
Understood. So I'll just
go into.
Understood. I will then just renew the objection where I find appropriate.
Thought his purpose, I understood, was to demonstrate that it did not appear that the bed had been slept in during the period indicated.
Since she left, since the note was placed there.
Yeah.
Right.
Okay.
Debbie, muskie is a tiger musculunge. That's how I pronounce it anyway. It's a fish that it looks like an alligator without legs. it's a long, narrow fish, massive mouth, sharp teeth, can weigh upwards of 40 pounds. Just amazing fish.
Did I veto a couple of them? No, I didn't.
Actually, I'm not sure if it's a tiger muskellunge. I think it's just a muskie. The tiger's the cross that they have in some of the states of that. I'll have to check on that. I'm pretty sure that the tiger muskellunge is a hybrid cross that's sterile, yes. And it's used for controlling bait fish.
You please do.
Okay.
Pretty much a dinosaur fish.
Detective, I again ask you to turn your attention to Defense Exhibit 60. You've indicated previously that's the bedroom. Is that correct?
Correct.
Okay. And that there was no DNA, there was no blood evidence that you saw in your opinion, in this room. Is that right?
Not that I saw.
Conditions were muddy and rainy on this day. Is that correct?
Yes.
Was there any evidence on the windowsill that you yourself noticed that somebody would have entered knowing that it's wet and rainy over the last several days?
Not that I saw, but I also can't say I examined it thoroughly either.
That's not something you focused on?
No.
Is there a pink note on the bedroom pillow in this depicted here?
Yes.
And is that a note appears to be the author appears, at least by the note, to be the daughter of Rosalio Gutierrez?
I'm going to object as far as foundation and speculation.
Well, I thought that's where we drew the line.
That was my impression that.
The defense's position is that it's not relevant what the contents of the note are or who authored it.
I certainly remember the first part. I'm afraid I don't remember the second part of that. The remark that I made at the time was that it was again a question about the sponsorship. Objections overruled, but I think that was the understanding.
Win for the state on that one?
That was my understanding.
Okay.
And I don't want the name of the individual, but does the note appear to indicate an author?
Yes.
And is that is the author a person related to Rosalio Gutierrez?
His daughter.
His daughter. Okay. And is the note placed physically on a bedroom pillow?
Yes.
Are you aware of when last Rosalio's daughter was located at his apartment so she'd have access to his bedroom?
Yeah, she was at the house on the 17th through the early afternoonish hour.
Okay. So that pillow had a note on it, and that daughter is under 10, correct?
Yes.
Okay. And she was last at the residence on the 17th in the afternoon?
Yep.
So the relevance is just for the time of death. He died after that because she was here. He wasn't dead then. We're going to try to be caught up to the regular live stream tomorrow. It just depends. We're running a little bit long tonight. I've got. Let me check the time.
Detective, what is your estimate on how many interviews you personally were involved in this case? What would be your general estimate?
25 or so.
And did that involve a number of people, a wide variety of people from all those different directions in this case?
Yes.
And at any point that you came upon something that was evidence that persons were involved somehow in the disappearance or murder of Rosalio Gutierrez, at each of those occasions, did you pursue that evidence when it was apparent to you based on all those interviews?
If I didn't directly, I would pass it on to other detectives that would follow through with that.
They had a really bad mic turned on to catch just general audio in the courtroom, and it picks up the fan. It's turned off now. You'll hear that when they walk around a little bit.
Thank you.
Yes, thank you, Judge.
Yeah.
I don't know if you want me to pull up the...
It's similar to a pike. Just me and Man Bun. It's similar to a pike. That's what you have over in England.
Thanks, Jessica.
Get a little bit larger, but massive fish.
So the state had in redirect asked you about that there were portions of the van that had been selectively cleaned. The area under where the missing carpet is, that area, to your observation, had not been cleaned, correct?
I'm sorry, what area?
Where the metal is exposed, that there was dirt and other items that show that area had not been cleaned?
Objection. The removing of the carpet would be the cleaning.
Well, I'm asking if under the carpet was cleaned.
Irrelevant whether you've cleaned under the carpet.
I don't think that's...
I don't want to preclude her examination, oral.
I can re-ask it. That
Please.
in that area, sorry, Detective, in that area where the metal is showing where the carpet used to be, there's a lot of dirt and other scraps indicating that that area hadn't been scrubbed clean, correct?
There is dirt and there is things over the metal.
That was a win for the defense.
Thank you. I don't need Exhibit 263. Thank you, State. The state had asked you about the efforts that you observed in the minivan were concerning to you, and you had said that it was not normal, correct?
Correct.
But you'd agree there are plausible other explanations for why an individual cleans a work van, correct?
I'm sure you could come up with some.
Okay. And the state had asked you about the screen door being open. You said yes, but you were not the first officer on scene, correct?
I was not the first officer, no.
So you wouldn't know how that door was observed when officers first responded?
Correct.
The state just now, the last question that it asked you, had to deal with all the interviews that you had with people, so I want to kind of break that down a little bit. You spoke with Michael Campbell, correct?
Yes.
He was just a friend of Mr. Gutierrez.
Correct.
You spoke to Eileen Knoll, correct?
Correct.
She was a friend of Mr. Gutierrez.
Right.
And they didn't provide you any investigatory leads, correct?
Correct.
You then spoke to Sadie Beecham, correct?
Yes.
And it was your prior testimony that she had immediately stated that she believed her ex, Zachariah Anderson, had something to do with it, correct?
Yes.
And you followed up on that one, right?
Yes.
All right. And you also spoke to Olivia Anderson, correct?
Yes.
And that was in relationship to Mr. Anderson, correct?
Yes.
You interviewed Mr. Anderson himself, right?
Yes.
And you interviewed Christine Remsburg, correct?
Yes.
That was the girlfriend of Mr. Anderson?
Correct.
So she only dealt with Mr. Anderson, right?
Yes.
And you interviewed, I'm probably going to butcher her name, but Casalina Remsburg?
I believe she went by Cassie, yes.
And that's Christine Remsburg's sister, correct?
We are getting caught
Again,
up.
relating
We are getting caught
only
up.
to Mr. Anderson.
Yes.
I mean, we've
And
covered
then
3
you
days
spoke
today.
with
We're going to catch
Andrew
up.
Schultz, correct?
Correct.
That was a friend of Mr. Anderson's, correct?
Yes.
And then you spoke to Alex Wetzel,
Yes.
again, a friend of Mr. Anderson's, correct?
I believe it was a cousin.
You talked to him only as it related to Mr. Anderson, though, correct?
Correct.
And then you spoke with an individual named Amber Stark.
Yes.
And she was the girlfriend of Alex Wetzel, correct?
Yes.
And that had to deal with confirming his whereabouts the weekend of May 17th through
Objection
May.
as to hearsay.
Defense.
I'll rephrase
Defendant
the question,
is
Judge.
Zachariah Anderson.
You spoke to her as it relates to your investigation of Mr. Anderson.
That was a win for the
And
prosecution.
then you met and interviewed Solomon Anderson, correct?
Correct.
And that's Mr. Anderson's brother.
Yes.
And then you interviewed Jennifer Libers, correct?
Yes.
And that's Solomon Anderson's girlfriend, correct?
Yes.
And then you interviewed Joshua Anderson, correct?
Yes.
That's Mr. Anderson's other brother, correct?
Yes.
And then you interviewed Zenith Anderson, that's Mr. Anderson's sister, correct?
Correct.
Then you interviewed Stephen Lenz, correct?
Yes.
That's a friend of Mr. Anderson, correct?
Yes. Correct.
So who did you interview that provided you other investigatory leads other than Mr. Anderson?
I didn't say I found any.
I didn't say.
I didn't say I found any other ones.
No further questions.
Were you just asked whether you spoke to Umdeen Labora?
Yes, that's another one. Kim?
Was that included in the list you were just asked?
No.
Okay, so that's not a person related to Mr. Anderson, is it?
Correct.
Okay, and when you spoke to Michael Campbell, he provided you information that
Defense is
Rosalía
20,
Gutierrez had
state
given him that
is
led you
16, I
towards,
believe.
The defendant.
I'm going to object as far as hearsay. Also leading.
Judge, there's just been a whole series of people listed, and they said there are no investigative leads that you pursued. I'm suggesting there are investigative leads on certain ones, and I'm asking, again, using the identical list of people that they just talked about. I'm not required to only talk about whether he found any leads that don't involve Mr. Anderson.
Judge, if I may, the state asked him, oh, you interviewed a bunch of people and you followed all those investigative leads. I then went into all the people he talked about. I asked him about Michael Campbell. He answered it. Now he's trying to go into exactly the information that Mr. Campbell had allegedly provided. And additionally, if the state is going to make commentary about what he wants the witness to answer to, I'm going to ask that that be done outside the presence of the witness.
Let's just...
Ooh, outside the presence of the witness.
Much of the evidence you're hearing throughout this case would ordinarily not be admissible under that big rule, the hearsay rule.
Show us a book. Pull a book out, Your Honor. That one.
I had a book very like this, and about a third of it, a third of the entire book, was about the hearsay rule. The hearsay rule is a very, very, very complicated rule. It has many exceptions, things that you might think would qualify as hearsay. And hearsay is evidence of an assertion made by a person while the person was not in court, under oath, and subject to cross-examination, which is offered in evidence to prove the truth of the matter asserted. So it's not anything that somebody said who's not on the witness stand. Sometimes that's what it is. But sometimes a lot of it isn't really being offered to prove the truth of the assertion. It's being offered to prove something else. And in those cases, it's not hearsay. Then if it is hearsay, it's subject to a large number of exceptions from the hearsay rule, which even though the testimony is hearsay, an exception permits its receipt into evidence. And believe me, we could take months and talk about this. But there are many times when hearsay does find its way into the court record. I've never seen a case in which so much hearsay has come in. And I'm not suggesting that it hasn't been proper or that the lawyers haven't used it properly, but you're hearing a lot of hearsay that would ordinarily not be brought in. The critical feature for almost all of it that you're hearing has been that it is not being offered to prove the truth of the underlying assertion. And we're at that point again now,
there. Do you see that?
Where I'm going to allow the witness to testify
how cute.
About what Mr. Campbell, what he claims Mr. Campbell said to him. And it's not being received for use to prove what Mr. Campbell is reported to have said is true.
Next hearing in Sarah-Boone is March 28th. That's a pretrial hearing.
Hear it for that purpose.
We'll see if the date for mid-April sticks or not for trial.
That the police investigation was deficient, and what the district attorney wants to show is that the police were investigating and did receive some information, and then made a determination about whether it was worthwhile pursuing or not. It is, again, he's not the final judge of what's true and not true. It's just he has to make a judgment for purposes of his position about whether this is something worth pursuing. The burden of proof in the case is totally unchanged. And then
murder trial is a great date idea. It's like, hey,
the charge against the defendant.
Let's meet up, grab some lunch, and go watch a murder trial.
And what leads the officer decides to follow and those that he doesn't are really not relevant to that. And all this evidence that is coming in that is ordinarily hearsay is being received just in response to the defense claim that the case wasn't properly investigated. and I might add, in my final comment, is that the huge portion of the book about the hearsay rule, I can still remember the first sentence. There is nothing murkier in the law of evidence than the hearsay rule. So it's a very, very complicated rule, but I just want to caution you in this case that ultimately you must rely on facts which are proved by the case and are proved by proper evidence, and that are sponsored by the person who, generally sponsored by the person who's making that assertion, who's here and subject to cross-examination. I know I could have done a better job of this, but is there anyone who has any question about this? Okay, I'm going to overrule the objection and
that's a win for the state.
With that understanding.
So, Detective, my question was, I'm not asking for the content, but was Michael Campbell a person who provided information to law enforcement that would conclude, that would lead them to go to further their investigation of the defendant?
Yes.
Did Eileen Knoll, when questioned about what circumstances she was aware of and helpful on, did that cause you and other law enforcement to further direct your investigation towards the defendant?
Yes.
Did Sadie Beecham, in her interview, give you factual circumstances and things to investigate consistent with the defendant being the person responsible for these crimes?
Yes.
Did the defendant's daughter, when interviewed, give you information, eyewitness information and witness information that would lead you to further investigate the defendant?
Yes.
Did Christine Remsburg, the defendant's girlfriend, provide you substantive information that would lead you to continue and further your investigation of the defendant?
Yes.
Did Cassie Remsburg, her sister, provide you information that was consistent with that as well?
Yes.
Did members of his family, of the defendant's family, provide some information that would direct you towards the defendant and continue your investigation focused on the defendant?
Yes.
Did Stephen Lentz, when interviewed, lead you to have additional information that would lead you towards the defendant?
Yes.
So all of those people, when you interviewed them, again, led you in terms of following evidence towards the defendant. Is that correct?
Yes.
Nothing else?
Those people that led you to information about Mr. Anderson, none of them provided any information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020, correct?
Objection, that's outside the scope of my question.
I think it's exactly in scope of his questioning.
Well, actually, as I've repeatedly said, I'm usually not too rigorous in the application of that rule, but we're getting close to the point where my rigor may return. So you can have an answer to this one.
Could you repeat, please?
That's a win for defense.
That those individuals that the state just asked you whether the individuals you talked to gave you information that pointed you in Mr. Anderson's direction. Now I'm asking if any of those witnesses, or actually stating none of those witnesses, provided you information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020. Correct?
Correct.
Nothing further.
Nothing on that specific question.
All right, you may step down.
Well, that's the only one you get to address. It's funny. I think the DA lost.
Co-counsel and just inquire about next.
Yes.
They're going to huddle up for just a minute.
How many Brewers fans here? One? Two. You don't have to be embarrassed about it.
What fans? He's asking about sports.
Cubs? Okay, 3-3.
Cubs? He's talking, I guess it is baseball. So he is a baseball fan, and he's questioning the jury right now.
Sometimes there's a few other teams.
DA lost that round. The DA hits back hard. He tries to get the win, but she is really sharp. The defense is just amazing. So
I'll lengthy.
Short witness. We've conferred this will be a very short witness, and then we have a stipulation to read, and then we will close evidence for today.
So many stipulations.
Thank you.
Is that accurate?
Yes.
Adam says, "Go Cardinals." DMB's more of a Yankees fan. Now Cubs, Brewers. We've talked about both of those. Yep. Miller time for the detective. At least he's done. Here's the very short witness. I don't know why we have to comment about her height, but that's what they said.
Raise your right hand, please.
Andrew, thank you very much.
Will be the truth, the whole truth.
Appreciate it. I love this stuff.
So
So
please be seated.
looking forward to enjoying watching these with you.
Ms. Swanigan, could you please state your name for the record and spell it?
Marissa Swanigan, Marisa, Swanigan, Swanigan.
And are you currently employed in some way?
Yes.
And what in general do you do?
Management.
I'm going to direct your attention all the way back to May of 2020. On May 17th of 2020, were you living at the Wood Creek Apartments, specifically 3709 15th Street, apartment 2B?
Yes.
And that apartment, was that on the first floor, second floor, or somewhere else?
The second floor.
So did you have a downstairs neighbor directly below you?
Yes.
And did you know him in passing, just being essentially apartment mates?
Yes.
And did you know anything about his family situation in passing?
Just 2 kids that I would see in passing.
And were they young kids, probably 12 and under, let's
yes.
say? Did you know if 1 boy, 1 girl, 2 boys?
1 boy, 1 girl.
Okay. And do you recall having contact with law enforcement on the 19th of May of 2020, where they asked you, did you hear or see anything on the days preceding that caused you some sort of concern from the downstairs apartment?
Yes.
And what, if anything, do you recall telling law enforcement about your observations that they were asking about?
Just hearing loud banging, like against the wall.
And was this specifically did you have a specific night that you had heard this?
It was a Sunday night.
So that would be May 17th?
Yes.
And when you heard this, approximately what time was it, if you recall?
Between 10 and 11.
And where were you in your apartment when you heard this noise coming from downstairs?
In my bedroom.
And at that time, were you living in a 1-bedroom apartment?
Yes.
And was your bedroom at the back end of your apartment, so all the way through?
Yes.
And based on where you were in your bedroom, could you tell in general where this banging noise was coming from?
Yes.
And how are you able to make that determination?
It wasn't coming, the sound wasn't coming directly from under me. It was more so further in front but below me, if that makes sense.
And so in your knowing the layout of the apartment, what room of the apartment below you did you believe this banging to be coming from?
The living room.
And approximately how long do you remember this banging to have occurred on the 17th between approximately 10 and 11 p.m.?
About 5 minutes.
And at that time, did you hear any speaking or any sort of anything else, or just the banging?
Just the banging.
And in your experience as a human being, did you have any sort of thought as to what that banging could be in your mind while you were in bed hearing it?
I initially thought maybe something that was really big might have fell, or if the kids were still there, that they were playing around and they knocked something over.
And you said the banging went on for approximately 5 minutes?
Yeah.
And then once that 5 minutes stopped, did you hear anything further?
No.
And obviously, hearing that banging, knowing that kids sometimes are downstairs, you didn't call 911 that night?
No.
But when asked about, had you heard anything in the days preceding the 19th of May, that's what you were able to tell officers?
Yes.
And you were for sure it was Sunday night between approximately 10 and 11?
Yes.
That's where they get the time of death from. Between 10 and 11, she heard the banging. Her style's really good. She was not leading at all. These were really good questions. Doing a better job, I think, than the DA.
I have nothing further. Thank you.
Thank you. Good afternoon.
Hi.
Hey. So just a couple of follow-up questions. This banging or the sound that you heard, you said in between 10 and 11. Do you remember if it was closer to 11? Do you have a more specific time?
I would say closer to 10, like a little after 10.
And when you spoke with law enforcement, do you remember telling them that you didn't see anyone or you didn't see any cars?
Yes.
Did you look out your bedroom window?
No.
Okay, so you were just staying in bed?
Yes.
Okay. And so all your observations was this sound?
Yes.
And prior to hearing the sound, I hate to go into your whole sleep schedule, but got to do it. How long were you in bed prior to hearing that sound?
Maybe 2 hours.
Okay, and were you awake and in bed?
Yes.
Okay, and prior to hearing this banging sound, did you hear anything else suspicious?
No.
So you didn't hear any screams?
No.
You didn't hear anyone arguing?
No.
And I want to talk about the apartments in general. How long did you live there for?
About 3 years.
Okay. And clearly you could hear what had happened when you heard this banging, but in general, tell me about how private that apartment building is as far as being able to hear what's going on in your neighbor's apartment.
It's pretty quiet.
But can you hear things coming from the apartment across from you or below you?
It would have to be really loud, but if it wasn't, yes.
And so after you, and you're sure that this was Sunday night?
Yes.
Okay. Did you hear anything the following day?
No.
Okay. Did you see anything the following day?
No.
And were you there the following day, or were you at work?
I was there.
Okay. All day?
I believe I went to work at 9 o'clock Monday night.
Okay.
Little Miss, thank you so much.
Do you remember telling...
Looks good with green next to your name there. Appreciate your support.
Law enforcement that you didn't hear any sounds of glass breaking?
Yes.
Okay. But you said that, I'm just trying to really get what the sound was that you heard. I know it's hard. I know it was a while ago. And you previously described it as something falling off the wall. But is there any other way that you can describe this sound?
It sounded like just something big being forced against the wall.
Okay. In the living room?
Yes.
At this speed, we've got about 35 minutes roughly left.
I don't have anything further.
No, nothing further. Thank you.
You may step down there. I think you folks have put in a full day, and it's a good time to stop.
Can we read the stipulation?
Can we read the stipulation?
You may.
Okay. Counsel, we're prepared to read the stipulation.
Yes, I would like to read the first part.
Okay, any of my copy? I'm happy to do that.
Okay, sure. Thank you. So cordial. So we have a stipulation. I'm going to read the first part, Judge, and then the state will read the second part. The following are statements attributed to Lene J. Douglas, who is an unavailable witness in this matter at this time. The parties have stipulated that these two statements should be read in their entirety to the jury in place of testimony that Ms. Douglas would have made if she had been available. Officer Paul Chase, on May 19, 2020, reported, quote, I did speak with Lene J. Douglas in number 2C, end quote. Quote, Douglas told me that she thought that she heard an argument from apartment 1B yesterday, May 18th, 2020, afternoon, around 13 hours. She knew that the subject in 1B had kids and did not think anything of it. Douglas went on to say that she did not see who was arguing, end quote.
Members of the jury, the second part of the stipulation is as follows. Lene Douglas telephone call on March 10th, 2022 with DA Mike Gravely and Victim Witness Coordinator Heather Beasy. Ms. Douglas was asked about her verbal statement to Officer Chase, in which he had her saying that she had heard an argument in 1B on May 18th, 2020 at about 1 p.m. Ms. Douglas stated that she could not be correct. Stated that could not be correct because she was working with headphones on for her job from her back bedroom on Monday, May 18th at that time and would not have been able to hear anything. She stated the officer must have misunderstood what she told him. She stated that when she heard something concerning apartment 1B, she was in her main living room, comma, it would have been about 9 p.m. because she was watching TV. She stated that it was in the few days prior to May 19th, 2020, when she heard at approximately 9 p.m. a scream in the hallway by 1B. She described the scream as high, as if someone was in pain and surprised. She stated that she could not hear anything further, which surprised her because based on the original scream, she thought she might hear a call for help or something. That's the completion of the stipulation, and of course, this has been filed with the court. It's been provided to the court.
Right. Folks, again, with the stipulation, that's
co-read that.
Something the parties agree as being the true fact, and so that's something that you should accept, and no further proof will be received or received to either prove or disprove what is agreed to. Any question about that? Okay. Anything else?
No.
Okay. Let's break for the day. 9 o'clock tomorrow morning. Please don't read, watch, or listen on any account of the trial. Don't discuss the case even with fellow jurors or members of your household, and we'll see you tomorrow.
Okay, so the jury's going to leave, but we're not quite done yet. So hold tight here. Waiting for them to leave. Maybe we should play some music or something. Okay, the jury's almost out. We're going to sit down and discuss some more stuff because these lawyers have a lot to discuss with each other.
Van Lee-Daubert issue, I don't think we've had that yet.
You're right. Yep, I think that's a good idea. Yeah, that's a good time to tell me. Get out of here. All right, I have a number of observations on the Van Wheat testimony.
Van Wheat?
Offered testimony.
So far, yes, objections-wise, defense was ahead by, let me see the final score. Looks like they won by 3.
The first observation that I want to make is I thought it was very clear from the argument that has been made here that there is no dispute as to the scientific basis for the methods and principles which were employed in this case, although there's dispute as to the qualifications of Officer Van Wee and the method in which he did his observations and analysis. But I did not understand any dispute as to the basic science of it. And the requirement for the admission of this type of testimony, as stated in 907.02 subsection 1, is that scientific, technical, or other specialized knowledge will assist the jury to understand or determine the fact and issue, that the expert witness testifying is qualified as an expert by knowledge, skill, experience, training, or education, that the expert testimony is based upon sufficient facts or data, that the expert testimony is the product of reliable principles and methods, and that the expert testimony has applied the principles and methods and
it was the judge's phone.
And methods reliably to the facts in the case. And the defense objection states that the defendant maintains that Officer Van Wee's testimony regarding his observations and conclusions of the blood evidence is not admissible for the following reasons. One, that he is not qualified as an expert in the field of bloodstain pattern analysis. Second, that he does not comply. His report does not comply with industry standards and requirements. And third, that Officer Van Wee failed to reliably apply principles and methods and made substantial errors in his report. And the defense position is largely based on a report submitted by Dr. Marilyn Alice Tebbs Miller, and she has made a number of attacks on Officer Van Wee's performance in this case and the contents of his report. We discussed at some length the other day, and I pounced, as I frequently do, when Attorney Mueller started talking about standards and requirements, and I challenged that to basically according to whom, and I think the response was the Department of Justice. And I have to say, I haven't made an exhaustive search, but I haven't found these standards from the Department of Justice. I think I made pretty clear that I'm not familiar with any authority that I'm required to follow standards of the Department of Justice. I'm not familiar with any legal authority for the Department of Justice to proclaim or enforce standards on the state courts. And I'm not suggesting that the Department of Justice may not have done so, but the Department of Justice has done a lot of things that are in the courts right now, actually.
I don't think it's a public defender. He had $50,000 cash on
the
him.
Supreme Court right now as to the reliability and the legality. But even assuming that they've made suggestions as to what standards courts should apply, I'm not familiar with any standards which I am required to employ. Certainly, I've not heard of any constitutional, under the federal Constitution, that I would be required to do so. And I've not seen any that set the standard for state
the
law.
Rittenberg
In fact,
case, same judge,
both
same
the United
courtroom.
States Supreme Court,
Kyle Rittenberg.
from the beginning of Daubert, and the state Supreme Court from the beginning of Wisconsin's use of Daubert, has I have deliberately veered away from a course of imposing strict standards on trial judges, and to the point that
Rittenhouse. I said Rittenberg. Oh my goodness.
Nobody
jump on me. Nobody else tell me. Just one person correct me. I'm
Whatever
just
they call
kidding.
the Wisconsin lawyer now.
Kyle.
I guess it's the Wisconsin lawyer.
Hausberg, Iceberg, Rittenhouse.
Comments on Professor Blanca's splendid.
It's been a long day.
primer on,
Heisenberg.
Daubert evidence.
Hindenburg.
And the fact that Professor Blanca said Wisconsin was a lax Daubert state.
That's the judge's phone again. Space Invader sound. Thank you. Thank you, DMB. Say my name.
In assessing what the
Adam Tomita.
appellate courts have demanded of the trial courts. And Judge Apremian has not necessarily agreed with that.
Berg,
I
you're
think
right.
he's suggested that
Go Burger.
the individual states' laws have really defied easy definition of what is a lax and what is a strict application. But so as I say, I think that Ms. Mueller made reference to
Ivan, I want you to call in as soon as this is done. We've got a few more minutes, but I'll
I think that was my word, controlling. But on
hold tight.
the
Don't call
idea
yet.
that these standards are to be followed in order for the
Okay.
witness to be qualified.
If
And
this judge is just going to keep yapping, which is good. I mean, he does a good
I
job.
don't think there's any control.
I just want the
element
answer
in
out of
it.
him right now.
She's advocating adherence to the standards of the organization to which she pays dues and belongs, and I think has been an officer.
Okay, we're going to
but,
fade this out. I will listen to this, and I'm going to sum it up for you at the end of this.
Why they would be preferred to a lot of other criteria.
We're gonna fade that guy out. I will tell you what that decision was. The beginning of the morning, because it's basically a decision on testimony from this witness. Here's what we'll do. Let me plug in my burner phone, and Ivan, I'm going to see if I can get you to call in here. Just let me plug in my burner phone. Whoa, and that was me. Clear. Hold tight. Let me get it all set up here. Okay. So, Ivan, see if you can give me a call here real quick. We'll see if we can get this to work. Meanwhile, in chat here, I'm going to send a quick message.
Call from Ivan Victor.
Ivan, musky champ extraordinaire. How are you doing today?
I just had a drink go down the wrong tube. Pardon me.
Perfect timing.
How are we doing?
We're doing great. I was going to share one more time. I was going to share a link. I told most of chat I was going to do this, and at the beginning, but I forgot. Let me get back here to the other page so I can actually have the link. Ivan, for those of you who don't know, has a YouTube channel that I think deserves a little watch. It is and a subscribe as well. I think you've got almost like 150 followers right now.
It's a wholesome channel.
It is.
It's not what you think.
Yeah, it's super good. It's super good. It features a little dog named Rebel who rules Ivan's life. And if you think Ivan's like a tough guy, this dog has him wrapped around her tail. It's just anything.
He humbles me daily. Let's just say.
Yes. So I wanted to share this. Let me just post this in chat here one more time. Why is it not going?
Yeah.
I'm trying really, really hard to copy this, and it's not copied.
Stop that barking.
Okay, so save that. Click that, right-click it, and say open a new tab. That's what you want to do. You right-click on that link in chat right here, and open a new tab. Ivan, before we close out, you brought something up that I thought was interesting. You said you take a lot of a pride in your hometown, and that this rings.
100%.
Say that again.
100%.
That rings like a bell inside me. I love, anytime I want to go somewhere, I want to find the people who are like you for your hometown, who know everything that happens, who knows the history, who values, what.
I am a hometown nationalist, as it might be called.
So you should be, I believe it should be a requirement to have that skill if you're like a tour guide or, anyone in the tourism industry.
Well, especially if you own a business and if you are a part of the fabric of the town, I feel, and don't get me wrong, I am a transplant. You can hear Rebel going off in the background. I am a transplant in my own city, but yet still, I am a nationalist of this town. I feel your roots are everything. Yeah. That's just how I am.
That's cool. If I was not doing this, if I was not doing true crime, I would do a show where I find people who just have tons of hometown pride and have stories and information and all, like the stuff that, the old timers know, the information, the knowledge about the town, where it came from and what's really cool about it.
Sure.
And I'd be interviewing them. That would be my dream job.
It's funny you say that, R.A., because me and my cousin, who is literally from the motherland of Russia, I literally brought him over here. But one of our ideas for a podcast has been to go to the local trailer parks, where I feel like is the heartbeat of our town. You know what I mean? Like I feel like those are the realest of the real people of our town, and just interview them on the latest what's what. The latest what's happening, the latest, like, what do you know, that kind of thing.
I love the family stories, just the backgrounds. There's so much. Anyway, you said that, and immediately it like rang a bell in me. Said, yes, this is so true. I love it. I've moved. Sorry, my nose is itching like crazy. It's the pollen here that's going crazy. But I moved from out west out to North Carolina a couple of years ago, and this is now home for me, and I love it. Yeah. I moved out here and just. I fell in love with the people, with the history, with the weather, with everything, and just I love it. So this is hometown for me now. But awesome.
I love that you put your roots in. I love that you everybody. In my opinion, it may not be for everyone, but I feel like wherever you are, plant your flag. You know what I mean? That's all we have. Plant your flag, get your roots in, and start a story. Yeah. That's what I think. Anyway,
that's awesome.
I don't know.
Well, I hope Ivan that you beat me to 60,000 subs on your YouTube channel. I really do. Rebel deserves it. She's an amazing little dog, cute as a button, and
she will become a diva if that happens. No, all I say is you get to 60,000, I get to 1,000. We are off on the right path. I will gladly be your wingman, sir.
That's awesome. Well, Ivan, thank you very much. I just wanted to put your voice out there with your name. We see you in chat every day, and we love it. Ivan, you're awesome. I appreciate your insights, just how real you are. Calling it how you see it.
Thank you.
Do it in a civil way, and it's just, it adds a lot to the channel. There's many people just like you out there.
And for people in the chat who can't seem to find it or didn't click the link, all you have to do is literally search my name as it appears in the chat in the YouTube search. You will find it. It will be the first one that pops up. But thank you, RA, for promoting it and supplying that link. I am forever grateful.
Yep. It's awesome. Ivan, thank you very much. We'll chat soon. I know we're going to have open lines again. So thank you.
Amen.
I think it's been a long day. Other than that, I'm going to let you go, Ivan. Thank you very much. Have a good night. Go catch a fish or something. Ta-ta. All right. Bye-bye.
Bye-bye.
All right. So Ivan's awesome. Anyway, I seriously do give his channel a subscribe. I'd love to see it grow fast, and the little dog deserves it. I mean, a cute dog. You can never have enough little cute animal videos in your YouTube timeline. It'll take just a couple minutes to watch a video. It'd be great. Anyway, so we're going to end it here because it's been a long day. It's been a long day. I'm gonna be staying up tonight watching all the next stuff so I can trim down tomorrow's and get it so we can get caught up. I want to be back to real time so we can watch this as it happens in real time. It'll be a bit more fun. Hopefully we can get there tomorrow. I hope we can get caught up. There may be some things I might have to summarize for you just so we can skip over, especially if there's something really boring. But we'll get caught up. We're going to watch this trial. This is basically going to take us most of the way to the Sarah Boone case. We're hoping that one sticks. Sarah Boone's going to be an amazing trial. It's slated for the middle of April. It might push. We'll find out the end of March for sure, but it's going to be good that way. So thank you. We're going to go live again tomorrow. Thank you so much to Adam Nusky, who owns the internet today, and throughout the night. If you have any internet problems, just reach out to Adam. He will resolve them all like he did today. So thank you very much. If you're not a member or a subscriber, please consider doing it. If this is a channel that you like, you enjoy what we do here and how we do it, we'd love to have you make a home here. We'd welcome you with open arms, and we'll never let you go once you join. So anyway, thank you very much. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be at 9 a.m. tomorrow morning, 9 a.m. Eastern time. We'll be live again. So thank you very much, guys. Have a great day.
Are we